Good morning, everyone. Good morning, everyone. Welcome to our first day of our spring oral argument session here in our state capitol in our Pennsylvania Supreme Court courtroom. President Theodore Roosevelt attended the dedication of this building in 1906, declaring this to be the handsomest state capitol he had ever seen. The architect of the building, Joseph Houston, envisioned this to be a palace of art, and in this chamber truly embodies that vision. 96 years ago, the Supreme Court of Pennsylvania convened at 3:30 in the afternoon to unveil the majestic violet Oakley murals that surround you in this courtroom. We are privileged on our Supreme Court to sit in three majestic courtrooms in Philadelphia, Pittsburgh, and here in Harrisburg, but nothing compares with the gorgeous setting here, the majesty of justice as exemplified by the violet Oakley murals. So I hope that while you're here, not while you're arguing, but perhaps afterwards, you'll take a moment to enjoy these murals and really take them in. Violet Oakley was a woman of incredible talent and vision. The murals project for the Capitol was the largest commission ever awarded to an American woman. Remarkably, Violet Oakley, a young Philadelphia artist, was selected for this daunting assignment at a time when women could neither vote nor hold elective office. Ultimately, she devoted 25 years of her life, from 1902 to 1927, to painting the 43 murals in our state capitol building, beginning her work in this room in 1917 during the First World War. Violet Oakley went on to become one of the most respected artists in America. Her vision for the room was to write a book on the evolution of law, and the murals in this room may remind you of the pages in a medieval or Renaissance manuscript. She describes the evolution of law as a musical scale in E minor, beginning and ending in divine law, one octave higher. So while you're here, please try to take them in. I wanted to make a couple of announcements before. First of all, you'll notice that Justice David Wecht is not here with us this morning. We're sad to report that Justice Wecht's father, Dr. Cyril Wecht, passed away yesterday, and we send our deepest condolences to Justice Wecht and to the Wecht family. Justice Wecht will still participate in the disposition of these cases. He's already prepared for oral argument. He's read your briefs, and he will view the videotapes of the arguments at a later date. Secondly, I just learned that the Attorney General's office lost one of its luminaries, Attorney Howard Hopkirk, and I wanted to extend my condolences to the members of the Attorney General's office who are here today. A couple notes for counsel. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of your case. You may then begin by stating your name, the party you represent, and please introduce your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. Please remember, we do not permit rebuttal. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as your prior counsel. Please try not to interrupt the justices when we are asking you questions. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we want to explore further. While there's no set time limit for argument in our courtroom, I will advise counsel when the court is satisfied that all of its Questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, would you call the first case?
Firearm Owners Against Crime versus Colonel Crystal Harris, Commissioner of Pennsylvania State Police, representing Firearms Owners, Mr. Joshua Prince, representing State Police, Mr. Daniel Mullen.
This direct appeal involves a petition for review filed in the Commonwealth Court alleging that the Pennsylvania State Police is in violation of the Uniform Firearms Act because it purposefully understaffs the Pennsylvania Instant Check System, which performs background checks for firearm purchases and transfers, as well as for individuals seeking or renewing a license to carry a firearm. The petition alleges that the understaffing causes significant delays, thereby violating the rights of applicants seeking the background checks, and causes prospective purchasers of firearms to cancel purchases, depriving retailers of income and causing them to incur unnecessary costs. The petition sought injunctive, mandamus, and declaratory relief, enjoining the state police from further noncompliance with the statute and directing the state police to hire and train new employees or to repurpose existing employees to ensure that background checks are performed instantaneously. While a single judge of the Commonwealth Court granted a preliminary injunction, a panel of that court later vacated that injunction, finding that injunctive, mandamus, and declaratory relief was unavailable. We granted allowance of appeal to examine the propriety of that determination. Good morning.
Good morning, Chief Justice Todd, Justices of the Court. May it please the Court. My name is Attorney Joshua Prince, and I represent James Stoker, Landmark Firearms and Firearm Owners Against Crime in this matter, which involves, in its most simplistic terms, whether an administrative agency may shirk its statutory obligations and evade judicial enforcement of those statutory obligations in toto, as the Commonwealth Court held. In this matter, the General Assembly made the basic public policy decision that the background check system utilized for purchasing firearms or transferring firearms was to be instantaneous.
But can I just stop you one moment? How is anything instantaneous? Could you just explain how that would even be possible?
Through computer systems, I believe something can be instantaneous, and that's actually what's utilized by the Pennsylvania State Police, is they submit in the information and it immediately is supposed to provide a response. The same is true of the federal system, the National Instant Check System, that also the Pennsylvania State Police queries in doing the background checks. But this, again, was a decision by the General Assembly to have a law that required the Pennsylvania State Police to implement a system that would perform these background checks instantaneously. And as this Court has consistently said, those are the decisions for the General Assembly to make. And it is for the Pennsylvania State Police to carry out that mandate from the General Assembly.
And I'm open to your argument. I guess my concern simply is the legislature prescribing something here that is impossible?
We don't believe so, and the General Assembly did not believe so. If that's the issue, the Pennsylvania State Police can always, like anyone else, petition the General Assembly to change the law. They have not come forth and ever stated that it's an impossibility for them to perform the law that was put in place back in 1995, and they were given 3 years until 1998 to implement the instantaneous background check system. Beyond that, the law also required, when the Pennsylvania State Police utilizes the system, to immediately, that's the word in the statute, immediately inform the licensee, the gun dealer performing the background check, as to whether that individual was approved or denied.
But, Counsel, the General Assembly hedged its bet.
And I'm sorry, Your Honor?
The General Assembly hedged its bet by saying either immediately or by return call forthwith. And so the General Assembly appreciated that immediate may not be possible.
I don't believe that, at least in my opinion, is a proper read of the statute. And we addressed this before the Commonwealth Court as well as before this Court. and there still has not been any response by the Pennsylvania State Police Commissioner in this regard. The forthwith language was added because when the statute was enacted, there was not an ability to submit these inquiries through the computer system. They were done via telephone. And what the General Assembly was precluding was a situation where the Pennsylvania State Police would not pick up the phone and contend they had no inquiry to which they had to respond immediately to. So by including that phrase, or return call forthwith, was to require that if the Pennsylvania State Police did not pick up the phone, that did not mean there was not an inquiry that they had to respond to, that they had to immediately respond to that licensee to process that background check. And when we look to dictionary definitions of what return call forthwith, specifically forthwith means, it means immediately.
Well, it may not. I mean, I think there's an argument to be made that it doesn't mean immediately. And, I mean, everything you say is interesting, except we are here to look at the clear language of the statute. Your background, to which you have apparently not gotten a response, I could see why that would be, because I think our job is to interpret this statute as it's written, and it says immediately or by return call forthwith.
And Justice Donahue, I completely agree with you. In fact, the precedent of this court, McClellan, says that this court is not to look to the spirit of the law when the words of the statute are clear. And here there can't be any dispute that the words are clear. And in fact, if I can give an analogy to the Statutory Construction Act, because there is another term that the court defined here, expeditiously. So there's two separate subdivisions that we're looking at. 6111.1 subsection B and C. I would proffer to the court that subsection C is the general provision. There it says the Pennsylvania State Police shall train and employ as many personnel as are necessary to carry out the provisions of this chapter expeditiously. That is the general provision, that expeditiously is the standard. But in relation to the background check system, expeditiously was not sufficient for the General Assembly. They provided a specific requirement of the Pennsylvania State Police that the background check system be instantaneous and that the response be immediate. That is a distinction.
What if they can't? I think the record reflects in the case below that about 65% of these particular applications were immediately by return phone call. There was about 35% where, for one reason or another, the state police couldn't process these applications, and they had to get back to the individual. In those cases, what if they can't do it? I mean, whose rights are paramount? The rights of the gun owner or the gun seller, or the rights of the public to be free from individuals that we don't want to procure guns from having guns?
Justice McCaffrey, it's a great answer, but the answer is simply that was the mandate of the General Assembly. The Pennsylvania State Police has to figure out how to carry that out. And we are talking about a constitutional right here. And in fact, these delays were not in relation to prohibited persons. These were in relation to people who were not prohibited, whose constitutional rights were not delayed just simply hours, but in many instances days, in some instances weeks on end.
What you're really asking us is to remand this case so you can amend the pleading to inquire into these particular issues?
Well, Your Honor, during the preliminary injunction hearing, we believe we brought out a lot of the information, and we did file a motion to amend or for leave to amend the petition, which was denied by the court. We wanted to include a lot of the testimony that came out during the preliminary hearing. Now, the one thing I would point out is after issuance of the preliminary injunction in this matter, and I don't dispute the fact that the Commonwealth appealed and there's an automatic stay of it. What was interesting is the delays almost went away in toto, almost. So Pennsylvania State Police does have an ability to perform these background checks instantaneously and provide responses immediately. And
Mr. Prince, I may misunderstand why this case is here. I understood the Commonwealth Court, and the reason why we're here is this really case doesn't have to do much with guns or even the statute. It has to deal with whether the Commonwealth of Pennsylvania, the state police, enjoys sovereign immunity from a declaratory judgment action, or sovereign immunity from an injunction, or sovereign immunity from mandamus. I don't really, the Commonwealth Court opinion sort of talks about the merits, but really only in relation to the relief that you're requesting. So do you want us to get to the merits of what this statute means, or do you want the Commonwealth Court to get to the merits of what it means and determine whether the state police is complying with it or not, which is pretty much a classic case that's before Commonwealth Court on a regular basis?
Justice Robson, I would agree with you with one exception. So I agree that the court dismissed our injunctive relief based on sovereign immunity and declaratory relief based on sovereign immunity. However, in relation to mandamus, there the court acknowledged that there exists the power of a court to compel a public official under mandamus to comply with a statutory obligation. And the Commonwealth Court then went in to define words such as immediately, instantaneously, expeditiously, and added
I guess that's a question. Did the Commonwealth Court in the context of mandamus actually define them, or did they simply say, because the words aren't clear and would require some form of statutory construction, you aren't entitled to mandamus relief?
I believe that's accurate, Your Honor, but I don't believe that they denied it on sovereign immunity grounds, is what I wanted to be.
So I guess that kind of gets to my point is, really the issues that are here are, is a declaratory judgment action and an action for injunction barred by sovereign immunity? And if the court has to decide what a statute means, does that mean mandamus is prohibited?
That's a fair analysis of it. Again, my concern is that the Commonwealth Court did go and actually seemingly institute what they contend their interpretation of immediate is.
I looked for the Commonwealth Court's interpretation of what they meant as immediate. All I read was them saying they really couldn't say that it meant that imposed an absolute duty.
They said there were some duties, but they didn't know what was meant. They actually said that they, in some sense, chastised the General Assembly for not defining what constituted immediate as well as expeditiously. I honestly believe if we go out on the street and we get the next 10 people to walk by, everyone knows what instantaneously, immediately, and expeditiously mean. But I would point the Court to the opinion at 11 where it says, "It is thus clear that the General Assembly intended that background checks and their results be communicated to the requester as efficiently and promptly as reasonably possible." That, I don't believe, is consistent at all with instantaneous or immediate.
What's reasonable?
I'm sorry, Justice McCaffrey?
What's reasonable in light of what we just talked about?
There is no reasonable aspect to the law. There is no, they shall perform these background checks immediately unless unreasonable or unless unable, or there's no exception. The General Assembly made that public policy decision that these are to be performed instantaneously and the response immediate. It is for the PSP to carry out that mandate or to seek to have the law changed.
But what if they can't do it? I mean, I think the whole crux comes down to the case, if we even get to it, is what that means. Because we've already talked about this, 65% of these, as we mentioned beforehand, are immediate. There's another 35% where the Pennsylvania State Police said for one reason or another, we couldn't process it. I understand your argument. I understand the gun owner. You're at a gun show. You're trying to basically consummate a deal to sell a particular firearm. You don't want the person who's prospective purchaser to be sitting around waiting for 3, 4, 5, 6, 7 hours. You're going to lose that sale. So you want that response right away, right?
Correct.
But what if there's one reason or another that the Pennsylvania State Police cannot complete the processing application within a timely manner, and they have to get back to you in some instances 4, 5, 6 hours later? Is that reasonable?
2 points, Justice McCaffrey. One, that would be for the General Assembly to add a provision to the law addressing that unique situation. Second, I go back to after issuance of the preliminary injunction, these delays pretty much went away. And I think that's important for the Court to note. So there really wasn't an inability of the Pennsylvania State Police to perform these background checks instantaneously and provide responses immediately. It's political gamesmanship that's going on. That is the only reasonable explanation for how within a week of the injunction going into place, all of a sudden, hocus pocus, these delays virtually disappear.
Well, counsel, isn't it fair to say that any individual organization that gets an order of the court jumps to the order of the court as opposed to political gamesmanship? This happens in a common pleas court all the time.
I would agree with you, Justice Dougherty. Absolutely, and we see that. Now, what was interesting, then, once the case gets dismissed, all of a sudden delays start coming back. And then, of course, once we petition this court for review, they start going away again.
Permit me to ask you this. A hit comes back on the criminal history. They don't have the ability to do a deep dive into that. So it's put on hold. Are you saying a scenario like that requires legislative fix as opposed to the statute being adequately applied?
I think the statute has to be applied as it's stated, and that response has to be immediate. If there's a hit that the person's prohibited, they relay the person is prohibited. If they don't have information that the person is prohibited, then there has to be an approval.
So let me take this to the logical extreme. You come in to purchase a gun, the state police does an investigation. The investigation involves a potential arrest in another state or country. Now you have to involve JNet or feds. If they call back and say, I'm sorry, we can't issue the license right now, we have to do further investigation, you're not getting your license or approval today. Does that meet the statute?
I don't believe it does. I believe that is something that the General Assembly would have to address specifically.
And I apologize. I'm trying to follow your logic. You're indicating that the statute demands immediate attention. It's mandatory with the use of, what is it, 6011(1)(c)(3)? Is it where it says the the Pennsylvania State Police shall.
B3, Your Honor.
And then it goes down to instantaneous.
Yes, Your Honor.
So correlating that, reading with the above section which says, as Justice Donahue said, or indicated, I'll call you back later, doesn't that satisfy the spirit and the text of the statute? If they immediately call you back and say, sorry, sir, Mr. Doc, we can't approve your application right now because there's something showing up and we don't have enough time or we don't have the capabilities of obtaining that record right now. Doesn't that meet the statute of immediate?
If they believe the person's prohibited, they can deny them, and then obviously the person can appeal that. There's a statutory provision dealing with that situation. I think the problem becomes what happens when, if you give them that inch, give them that ability to say, well, we don't have enough people here to process, we don't have enough information or that, and then it starts being utilized by political elected officials or appointed officials for purposes other than what are appropriate, meaning that it isn't truly that they don't have the ability to perform them that quickly or ascertain whether the person is prohibited, but rather because they want more money from the General Assembly, they're making these delays so that constituents contact their elected representatives, complain about the delays, the elected representatives contact the PSP, PSP says, well, we told you we needed $2 more million and you didn't give it to us, so now we can't do that until you give us that money.
I mean, I'm not sure the motives have any relevance as to what the statute means. I mean, I think you're not making your case wasn't brought because of an individual denial. Your allegation was there's a systemic problem, not that there's a one-off issue of somebody not being able to do that. Again, I want to make sure I understand. Do you want us to interpret what this means? Do you want us to go to the merits and resolve the dispute? I mean, there's obviously a dispute between you and the state police over what these words mean. There's a dispute between you and the state police factually over whether the state police is complying with the statute. This case was decided on POs. Shouldn't we deal with the sovereign immunity issue and what you have to allege for purposes of mandamus to overcome POs? And if you win, just send it back to Commonwealth Court?
I think that's one way to analyze it, Justice Brobson. My concern is whether the Commonwealth Court is going to simply point to their prior decision and say, this is our definition no matter what, even though you now have a right to mandamus, and that we're going to be back before this court.
I'm not saying you have a right to mandamus, but I think you have to establish what the statute means. Then you have to prove, and what the duties are of the state police. Then you have to prove that the state police is not following through with those duties. Then you have an affirmative duty that's established, proof that they haven't followed it, then you get mandamus. That's at least how I understand mandamus works.
Yeah, and it can be issued before trial, obviously, depending on what the record is, and we already have a record.
Well, you have a preliminary injunction record. You don't have a full record. You didn't do discovery. You didn't do anything like that.
Correct, Your Honor. And personally, I believe that the record already established before the court in the preliminary injunction hearing already shows the systemic issues with the system and that they're not being performed immediately.
Well, it shows the facts, but there still is a question over what the statute means.
And again, that's where I tend to think, and maybe Your Honor is more attuned to me, than me to what the Commonwealth Court would do in this situation, but I do believe that if...
Well, I'm not going to predict what a court would do.
But if you...
The question is whether the court did it and whether it's in front of us or whether the court sort of did it for purposes of avoiding a mandamus question.
And that very well may be. I just need to make sure the court's aware of the fact that in the opinion, the Commonwealth Court did say that mandamus is an exception to the sovereign immunity, and thus, as a result, they were actually going to review the merits. And so I'm not sure if this court doesn't address the merits, at least in some regard, or at least tell the Commonwealth Court that in the court's opinion, the merits were not actually reviewed, and is remanding the matter for review based on the fact that the plaintiffs do have the ability to seek injunctive, mandamus, and or declaratory relief. And
can you just stop there? You just threw together the three issues that you brought in great detail. What do you want us to do with the preliminary injunction determination of the Commonwealth Court? Were they right? Were they wrong?
We believe the preliminary injunction was correct, and that we did ask...
Not entitled to a preliminary injunction.
No, which, I'm sorry, when you said preliminary, I thought you meant the issuance of the preliminary injunction. If you're saying, were they correct that injunctive relief does not exist because of sovereign immunity, no, that's incorrect. And as we put forth to the court and the court did not address, this court in County of Allegheny versus Commonwealth actually reversed the Commonwealth Court's dismissal of an action against state officials and actually directed the Commonwealth Court to issue an injunction against the Bureau of Corrections as well as the Board of Probation and Parole. And I'll actually quote the case. It says, quote, "It is ordered that a preliminary injunction issue instructing the Bureau and the Board to take immediate physical custody of all male state prisoners in any of the 5 categories identified by the county who are currently housed in the county jail." There is clear precedent by this court itself directing that an injunction issue and that it's not barred by sovereign immunity. Similarly, as we reviewed in our briefing as well, the Declaratory Relief Act also is not barred by sovereign immunity. We have the Tucker case and a number of other cases where this court has explicitly held that declaratory relief is not barred by sovereign immunity. Now, with regards to the Commonwealth Court's disposition of the declaratory relief provision, that is somewhat suspect. I'm not sure whether the court felt it was barred by sovereign immunity or not, because the court just said, for all the reasons we specified in relation to injunctive relief and mandamus relief, we hold declaratory relief is not available. So I can't honestly tell this court that I truly understand whether that determination was based on sovereign immunity or based on the fact that the court felt that the words immediate and expeditiously either were not sufficiently clear and the court then attempted to seek the spirit of the law, or whether it was something other. Your Honor, I suspect my time is about up. No? Okay. Very well. We have asked that this court basically vacate the Commonwealth Court's decision because we believe it's improper and not supported by the binding precedent. We have also asked that this court review the fact that the Commonwealth Court dissolved the preliminary injunction and either reinstate that injunction or direct the Commonwealth Court to issue a new injunction consistent with what this court believes the law to be. We also, in the alternative, have asked for an opportunity for leave to amend. That was also denied by the Commonwealth Court. We did specify in that motion for leave to amend the different averments that we would like to include. The Commonwealth Court just dismissed it, saying that there was no basis in the law even considering those things, even though there were a number of things that we averred in that occurred after issuance of the preliminary injunction, and there was no further hearing, evidentiary hearing, for purposes of getting that information admitted. So with that, we would just ask that this court reverse the Commonwealth Court, direct that either the preliminary injunction be reinstituted or a new one instituted and if this court believes appropriate, provide us with an opportunity to amend the petition for review. If there are no further questions, we will basically rely on our briefing.
Thank you, Mr. Prince. Let's hear from Mr. Mullen.
Thank you, Chief Justice, and may it please the Court. My name is Daniel Mullen. I'm with the Pennsylvania Office of Attorney General, and I represent the Commissioner of the State Police. My friend is asking the judiciary to impose an arbitrary 5-minute time limit on all background checks in Pennsylvania, a limitation that appears nowhere in the text of the Uniform Firearms Act. What the text of the statute actually requires is that the state police review criminal history records, determine if the prospective buyer is prohibited from possessing firearms, and then inform the sellers of that determination. And the statute says that this process must be done immediately or by return call forthwith. And since the 1860s, this court has interpreted the term forthwith in a variety of different contexts to mean the same thing.
What about the instantaneous language, though?
Your Honor, I think that conflates the PICS computer automated records check with the follow-up review and determination process by the human operators at PSP. And I think my friend sort of fundamentally misunderstands how that initial PICS check works, because PICS just tells us there's a record. It can't necessarily reveal if the record is an exact match for the particular buyer or somebody who has a similar name. And it doesn't necessarily reveal if the underlying charge is because of unpaid parking tickets or a crime of domestic violence. And it can't necessarily reveal what the final disposition is. Only human beings can determine all of this.
Doesn't the Pennsylvania police have access to those particular records? I mean, there's more than just a name out there. If I apply for a gun permit or to purchase a gun, it's not just my name. It's my name, my social security, my date of birth, my driver's license information. That's information that's provided according to the PICS check, and then they do the follow-up. If something pops up under my name, then they can instantaneously or expeditiously, I might say, check out the background to see if there's anything in there that's preclusive.
Right, you're right. So Social Security numbers are optional. I think there was litigation around that. So sometimes we have it, sometimes we don't. And PICS, you know, the testimony below called them sound indexes. PICS sometimes is over-inclusive and brings in results. So let's say it's somebody with a similar name, somebody like John Smith. You might get a record for a different John Smith, maybe born on the same day a year later. And we don't know that until a human being puts eyes on it and reviews it. And we don't always control, you know, the databases and what they're producing. So these are federal databases, and sometimes they just say the person was arrested for a misdemeanor offense in West Virginia, and that's all we know at that moment. And so we're going to have to reach out to the court and gather more documents and see what does the record actually say. And again, that's not something that can be done in 5 minutes in every instance. And I think,
Counsel, you keep going to the 5-minute thing, and I know the petition asks for some pretty specific relief in terms of the mandamus directive that they want and the injunctive relief that they want. But I'm going to pick up on the line that I asked Mr. Prince about. I read the Commonwealth Court's opinion in its discussion of mandamus and its discussion of declaratory judgment, its discussion of injunctive relief as questioning the jurisdiction of the Commonwealth Court to grant relief that it routinely deals with. The state has one view of what the law is. A petitioner has a different view of what the law is. We think our view is correct. We want the court to decide whose view is correct. And, oh, by the way, if the petitioner is correct, you need to order the state to comply with the law. Why isn't this case simply that? And why shouldn't we just tell the Commonwealth Court, it's just that. Do what you always do. Decide whether declare what the law is. Don't say things like, it cannot be said that the response time duty is so clear and precise as to be susceptible to mandamus relief. I don't even know what that means. The question is, what does the statute require? Is the state police doing it? And if they're not, order them to do it.
Justice Bronson, I have a slightly different view of what the Commonwealth Court did than you. So if you look at pages 10 and 11, I think the first thing that the Commonwealth Court did is it rejected my friend's sort of central premise that everything has to be instantaneous. So prior to this, it sort of outlines these competing visions of the statute. And the first thing it did is it said, here's what the statute actually requires. And so, you know, once it rejected this idea that everything has to be instantaneous, I think everything else is sort of downstream from that. And so, yes, what we had to sort of also get into some of the more specific requests for relief that he asked for, such as repurposing and hiring and refunding. But as I read the Commonwealth Court's opinion, I think the first thing that it did was it interpreted the statute before it. It interpreted these sort of disparate phrases that my friend is trying to sort of
Well, I agree with you.
Yeah.
It gave meaning to it. It
Yeah.
said expeditious, Merriam-Webster dictionary, all that other stuff. It does say, it does attempt to give meaning to the words, but then it goes, so it says, it's thus clear the General Assembly intended that background checks and their results be communicated to requesters as efficiently and promptly as reasonably as possible. Okay? Mm-hmm. Great. Then the next question is the state police doing that? Isn't that the next question? Once you determine what the statute says, then the next question is the state police doing that?
and my answer to that is absolutely yes.
I know, but the Commonwealth Court didn't answer that. The Commonwealth Court didn't answer that. They said.
Well, do they have to answer that? I mean, I read the opinion the way you read the opinion.
Yeah.
I read the opinion as essentially granting a demurrer. You are not entitled to mandamus relief because the statute is not clear and precise.
Right. I'm with Justice Donahue on this. I think what was before.
shocked.
Yeah. and here, but here's.
Doesn't happen often.
But here's why. I think the first thing that was before the court was my friend's theory of the statute. The first thing he asked for was a declaration that everything has to be instantaneous. And I don't think that.
Well, obviously it does, because the general. I mean, this is again my problem. Is obviously it has to be instantaneous because the General Assembly used the word instantaneous. The question is, what did the General Assembly mean when the General Assembly said instantaneous?
And if I can on that point, what it was referring to when it was saying instantaneous was the instantaneous records check. When you look at the section that deals with the duty of the state police, which is an entirely different standalone section, it's 6111.1b1, and there it's directing the state police to review the history, determine if the individual is prohibited from possessing firearms, and then inform the seller immediately or by return call forthwith. And given the nature of the review and sometimes the complexity of the determination, that can't be 5 minutes in every case. It didn't put a hard time.
You keep saying 5 minutes. I'm blowing.
Yeah.
I don't see.
It can't be.
I don't see 5 minutes in the statute. I don't see 10 minutes in the statute. I don't know why we're trying to put a time limit on it. But apparently, I might be in the minority here. I didn't have an interest in this case because it had to deal with the statute. I had an interest in this case because it really did seem to limit the Commonwealth Court's jurisdiction and extend sovereign immunity to the Commonwealth of Pennsylvania in a way that seemed entirely contrary with precedent and would actually undermine the Commonwealth Court's ability to do the very thing that it's supposed to do on a daily basis, which is decide what statutes mean and determine whether the government is complying or not.
And I think what was, again, the first step was whether to accept or reject his premise that the statute requires everything to be instantaneous. And it disagreed with that premise.
It says instantaneous.
It says the records check is instantaneous. It doesn't say, and I think that's an important distinction, Your Honor, and he has conflated those two things, and I think that's the sort of central error in his interpretation of the statute. The instantaneous records check is entirely distinct from the review and determination. Sometimes review is 15 minutes. Sometimes review is several hours or several days. It just depends, as I was saying to Justice McCaffrey, what is before the state police at the moment that we get the PICS result. Sometimes we have a lot of information. Sometimes we have to go out and get it. And I think the General Assembly understood that it was building flexibility into that statute by using the term forthwith, which again means reasonable amount of time under the circumstances.
Counsel, reading that in paramateria with Section 3 even, or just reading the statute in its complete text. B3 is the Pennsylvania State Police shall fully comply and execute and enforce the directive of this section as follows. So that's a mandate. So considering that this is regarding a constitutional right, it appears that the General Assembly has developed a statute which demands the state police to act instantaneously and immediately. Seems to be flying against your argument. So share with us why we should not just read the text of the statute Are you claiming that it's ambiguous, that when the state police shall fully comply with the mandates of this section?
I don't think it's ambiguous. Just to clarify something, that subsection 3 that you're reading from, what it's telling the state police to do in that particular section is develop and establish PICs, because it didn't exist yet. It gave the state police a number of years. So that's what they're referring to there. But no, I don't think immediate is ambiguous, immediate or return call forthwith, but we have to contextualize that language in light of what they're tasking the state police with, which is reviewing records and making a determination as to whether or not the person is prohibited. And it didn't put a hard time limit on that. And so again, I think the first step is to...
Counsel, I view your friend's argument as being dangerous to his position, because if he wants an immediate answer, the answer could in many cases be denied.
Your Honor, I agree completely. I don't think he's really...
As opposed to taking the moments or hours or maybe a day here and there to determine that there actually isn't a problem.
I agree completely. I think we sort of have two options. If the holding is everything must be instantaneous and that means a few minutes, then we sort of have one of two choices. We can either accept all of the sales or deny all the sales, and both, I think, present really serious problems. Right? In one case, we are essentially arming tens of thousands of potentially dangerous individuals. On the other, we're denying hundreds of thousands of individuals who should have the legal ability to obtain a firearm. We're denying their ability to get that. And so I think the General Assembly rejected these extremes, and it picked the very sensible middle course, and it wanted the state police to move quickly, absolutely, but it also contemplated that there's not always going to be the opportunity for an immediate answer, and sometimes it's forthwith. And even the term immediate is contextual. Sometimes immediate in some context is right away, and sometimes immediate is a reason, sort of tethered to what's being asked. And
so what did the General Assembly mean when the General Assembly said the Pennsylvania State Police shall immediately, during the licensee's call of a return call forthwith, review, inform? Mm-hmm. What did the General Assembly mean?
I think it meant that when there's an opportunity for an immediate answer, we give it, and when there isn't, you have to sort of review and give a return call forthwith. And so sometimes, if the task is you have to determine if the person is prohibited, step one is getting the complete picture, getting all of the information. And maybe we have to reach out to a court that doesn't have electronic filing. And I also think it's important that we're looking at sort of 2 years at the height of the pandemic, where we did have some staff turnover, where we had an explosion of firearm sales. So we were being asked to do more. We're being asked to do it during a pandemic. And we're talking about the difference between, for these follow-up requests, the difference between 15 minutes and 2 hours. We're not... That's a lot of words for what shall immediately mean. And you're saying that's in the Commonwealth Court opinion, what you just said. I think that context is part of the Commonwealth Court's analysis, is that the Commonwealth Court understood what the task of the state police was, which was to first get its hands on the records. I think what the Commonwealth Court said, and again, I'm completely wrong on this. I think what the Commonwealth Court said, and I think it's a question of law, is that for you to pass through a preliminary objection on mandamus based on a statutory duty, the statutory duty has to be phrased so clearly in the statute that you don't need a court to decide what it means. I think that's what the Commonwealth Court said, and they said, based on the language we're ascribing, we don't think the statute is so clear as to what your duty is, so therefore we're sustaining a PO and dismissing the demur, or dismissing the mandamus. I think that's what they said. Do you agree? I agree. So the legal question that I am interested in is that a valid PO to a mandamus? That someone can say the statute means X, the Commonwealth says it means Y, and because there is a reasonable dispute between the two of you, it's not entirely clear, therefore we're dismissing the mandamus action. Is that a proper ground for dismissal of mandamus action, because there's a dispute over what a statute means? Yes, I think if the statute gives inherent discretion, then... Well, no, that's not the answer. A statute can give discretion. I'm not talking about it. I'm saying
if there is a dispute over what a statute means, does a claim for mandamus fail?
I mean, I don't think the mere presence of a dispute means that. I don't think that's the only thing.
Without a dispute, right?
What's that?
You wouldn't be in court without a dispute.
Yeah, exactly. So I don't think it's simply that. I read the Commonwealth Court's opinion as first sort of interpreting the statute and rejecting his view that it requires this instantaneous review and determination in 100% of cases. And once you reject that, I think, again, I use the term downstream, I think the specific relief, whether you're talking about mandamus or injunctive, is downstream from that first step. And so, yes, I think in this instance, it said the statute is not so clear that there's zero doubt as to what is required from the state police. If we take 15 minutes or several days, it's not so clear that that's a violation of the statute.
You agree, though, so you're saying I shouldn't be worried, that you think if someone brings a mandamus action and says, we interpret the statute as imposing duty X on the Commonwealth, and the Commonwealth says, we disagree, we think it imposes duty Y, that dispute is not ground, that the Commonwealth Court has the power to decide what the statute means and then decide whether you're complying with it or not for purposes.
Yes, and I think the Commonwealth Court took a more nuanced view and did sort of go through each issue. So I don't think that's a real concern that they're just going to say, well, side A says one thing, side B says the other. That always means there's a dispute. And I don't share that concern, Justice Probson.
Counsel, was the Commonwealth Court correct in its holding that in this situation, or one like it, if you are not entitled to mandamus relief, sovereign immunity is going to bar a request for an affirmative injunction?
Yes, I think there's clear case law dating back to the 1960s and in Faber in the 1980s and since that says you cannot get affirmative injunctive relief under sovereign immunity. You can't sort of compel a state agency to do affirmative things. You can halt a state agency from doing something unconstitutional, and that happens all the time, and that's a very well-recognized exception. And what I think the Commonwealth Court said with respect to declaratory relief is, okay, generally speaking, you can get a declaration, but you can't sort of sneak in affirmative injunction and just label it as declaratory and avoid sovereign immunity. And I think that's what the Commonwealth Court was saying.
Why in the declaratory judgment section of the Commonwealth Court's opinion didn't it just simply say, we declare that the statute means what the state police says it means, and that's what it means? Why didn't they just say that?
I mean, again, that's how I read them as saying that, and perhaps it could have been a bit clearer. But I do think on pages 10 and 11, I think the first thing they did was set forth, here's what the statute actually requires. It goes through the parties' competing arguments. We have one person saying it's got to be instantaneous in every instance. We've got the Commonwealth Court saying the opposite of that. We think the statute requires what the Commonwealth says, which is it doesn't put a hard time limit on it. And so I think that was part of the analysis. And then it went on to sort of address the more particular things that they were asking for.
Yeah, but counsel, let me return to my original question to
Yes.
Prince. You keep using terms like discretionary and contextual. In the event that we agree that it's discretionary and contextual, if we accept Mr. Prince's argument that there's an intentional action on the part of the state police to deny people their constitutional right to purchase a firearm, why shouldn't we allow an amendment in this particular case in discovery to go forward to find out whether or not his theory is in fact correct? I'm not agreeing, by the way, for the sake of this question, that causation is proven in this particular case. But why shouldn't we allow the amendment to go forward with discovery?
Well, because the first step at POs is we have to parse whether or not, he's made reasonable inferences here. And I think, a lot of his petition are sort of unwarranted inferences that don't have any support anywhere. But again, the key flaw, I think, and he doesn't want to budge from his theory of the statute. His first flaw is he thinks everything has to be immediate and instantaneous. And I think once you reject that, that's really all we have to do is decide, is he right? Does everything have to happen in a few minutes, or does the statute build in more flexibility than that? And I think all you have to do is look to the plain language to reject his central claim. And to the extent there are sort of
You lost me. Why? There's an intentional slowdown denying people their Second Amendment rights. Say you had public officials that have press conferences weekly, and a particular public official is not calling on certain media outlets time and time and time again, and that's proven. Wouldn't that be a denial of a First Amendment? Well, we've seen cases like that. We've seen cases where media outlets bring a cause of action saying, we're being intentionally denied our right to ask a question. We're being denied First Amendment rights. Isn't it there's a similar analogy in this particular case with Second Amendment rights?
Yes, but in the First Amendment analogy, they have to first outline a colorable claim under the First Amendment, and they have to accurately describe what First Amendment law requires. And so even if you assume all the allegations in his complaint, what he's asking for is incongruous with the actual text of the statute. And so I think ultimately we're just here to review his statutory claim and sort of the specific forms of relief he's asking for. And
But again, what if we have an intentional action on the part of the state police or any other governmental agency for that case? Shouldn't he be allowed to amend and engage in discovery to find out whether or not that's in fact correct?
he doesn't want to amend, though, to change his legal theory. His legal theory is the exact same. And once we decide that that is incorrect, the specific allegations don't matter. Maybe there's another case out there where there's a different legal theory that has more nuance to it that could survive POs, but I don't think that's what we have here, Your Honor.
Can I ask a question? What definition of forthwith are you using interpreting this statute?
A reasonable amount of time under the circumstances, which is what this court has said many times, again, dating back to the 1860s.
Okay, because I looked it up in the dictionary, and the definitions that I find in our dictionaries across the board for the term forthwith is without delay or hesitation, with no time intervening, directly, immediate, and instantaneous. So I realize that there's been forfeiture acts that have used the language of forthwith as reasonably possible, but it bothers me that this statute does not contain any language of the words reasonably possible whatsoever in it. And so I'm at a loss as to how, if we were going to use the plain language of the meaning of forthwith, how we would come to that utilization of something outside of what our dictionary plainly describes.
Right. I recognize, Your Honor, that forthwith can one definition is immediately, but it already says immediately. So I think it's redundant if it's saying immediately and immediately. So I think forthwith has to mean,
isn't it?
What's
if
that?
It says immediately and immediately, it would be consistent reading of the statute.
I think it would be, no, I think it's saying immediately or by return call forthwith. And so I think if forthwith means the same thing as immediate, it's redundant. And that's why there are alternative definitions of forthwith. Yes, sometimes it means immediate, and sometimes it means reasonable under the circumstances. And in light of this court's, over a century of rulings that define it as a reasonable amount of time, I think we should assume that the General Assembly is aware of that inherent flexibility when it uses forthwith.
Was reasonably possible a defense that was raised by the PSP in this action?
I'm not sure I'm
in
following.
Response to the allegations of the complaint during the issuance of the preliminary injunction, was it the PSP's position that it was not reasonably possible to perform these gun checks instantaneously?
Yes, it's always been our position that yes, in 65% of cases where there's no record, those are automated approvals, no human being has any involvement, that there's a sort of minority of cases where it's just not possible to do it immediately because... Well,
wasn't the testimony of the Lieutenant Keeler from the PSP that provided to the court in the Commonwealth Court provided testimony that it was possible, but they needed to rather make changes in the way they staffed the office?
No, I think what she was talking about was getting back to sort of the pre-pandemic numbers, and given the fact that beginning in 2020, we've been doing a lot more work, that we needed more people to do it. But that doesn't mean that we're always going to be doing it immediately in every case. We don't know when a PICS flag comes in what the work is going to entail, whether it's going to be a 20-minute review or a several-day review. So, no, I think she was just acknowledging that we asked the General Assembly for more
But assuming that my recollection of what Lieutenant Keeler testified to was more accurate than your, and it could be and it could be not, I'm not suggesting that, but my point is that isn't that one of the reasons why this is a case that should go forward, to have a record made to flesh out whether the allegations of the complaint can be established because they've been pled?
No, because again, as I was saying to Justice McCaffrey, I think the sort of first error that my friend makes is he wrongly interprets the statute.
Well, I've already disagreed with you on the meaning of forthwith, so maybe Mr. Prince has a more accurate view of what the law should be in Pennsylvania.
Right. Well, you know, if this court were to hold that, then yes, we acknowledge that perhaps a remand would be important, but respectfully, I think in context that given that forthwith is modifying the review and determination process, and given the nature of that review and given the nature of the determination, that's not what the statute holds.
Thank you for your answers.
Yeah,
Any
thank
other
you.
questions, Justice Mundy?
Nope, I'm done.
All right, anyone else? All right, Mr. Mullen, thank you. That was well argued by both sides. Thank you very much.
Thank you, Chief Justice.
Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania, Mr. John Edward Kurtz, representing Mr. Kurtz, Mr. Douglas Cagliari, representing Commonwealth, Ms. Julie Scann.
In this discretionary appeal, the police concluded that an unknown perpetrator of a rape would likely have researched the victim, given the remote location of the victim's home, that the rape occurred while the victim's husband was not at home, and based on police experience regarding sexual predators. The police obtained a warrant directed to Google for Internet search records made on Google's search engine for the victim's name or home address during the week preceding the crime. Google's search identified an Internet protocol, or IP address, from which 2 searches were conducted in the hours before the attack, which ultimately led to appellant's arrest. We are asked to decide whether an individual has a reasonable expectation of privacy in his or her Internet search queries and IP address, and whether probable cause was established to issue the Google warrant. Good morning.
Good morning. May it please the Court, Chief Justice Todd, Justices of the Supreme Court. My name is Doug Tagliari, and I represent the appellant, John Kurtz. We're here today to discuss 2 main issues, as Chief Justice Todd just addressed. That is the reasonable expectation of privacy and probable cause. And I'd like to address those issues in that order.
Counsel, can I just ask you a quick question?
Yes.
Should we analyze them in that order?
It doesn't matter to me, Judge.
Well,
Justice
I'm just wondering
Robson.
if we decide there was probable cause that the affidavit was adequate, doesn't that negate our needing to decide the question of whether the Pennsylvania Constitution recognizes the right to privacy in Internet searches?
Well, Justice Robson, I think if the Court were to decide that probable cause existed, then in turn the Court would have had to have already found that there is a reasonable expectation of privacy, as probable cause would only be needed for the warrant if a reasonable expectation of privacy existed.
Well, but the point is, let's assume there is a reason. Let's assume you had a constitutional right to privacy. We assume without deciding it there was a warrant, and there was probable cause to support it. Period. So we don't have to decide. We assume that there was a right and there was a warrant. It would seem that the proper factual circumstance to address the question of whether you have a reasonable expectation of privacy in an IP address and search is an unwarranted search, is a warrantless search. not a warranted search.
Sure. I agree to an extent, Justice Robson, but our argument is, of course, that this particular warrant was not based on probable cause.
Oh, I understand, right. I'm just trying to figure out whether we should avoid the constitutional question if we can and resolve the probable cause issue first before we decide the constitutional.
Understood. Our position is that a reasonable expectation of privacy does exist in one's private internet search queries and IP address under Article 1, Section 8 of the Pennsylvania Constitution and Amendment 4 of the United States Constitution. This court for decades has extended a reasonable expectation of privacy to private electronic information and has not applied the third-party doctrine in those circumstances. Dating back to 1979, in this court's decision in Dijon, the court recognized a reasonable expectation of privacy in electronic bank records. Then 10 years later, in Malilly, this court recognized a reasonable expectation of privacy in pen registers or dialed numbers, filed phone numbers. Then more recently, in 2021, this court decided Pacheco. In Pacheco, this court recognized a reasonable expectation of privacy in real-time cell site location information, otherwise known as pings. Now, here in 2024, with the absolute prevalent use of internet search queries by everyone, we believe that a reasonable expectation of privacy exists in an individual's private internet search queries using their own IP address.
Is that a reasonable assumption, though, based on life today? Internet searches are so common. Does anyone really believe when they go on and search for something on the internet that that search will remain private? I mean, you're immediately hit through cookies, I guess, with ads for the product you were searching for. Does anybody really believe today that your internet search is going to remain private?
I think so, Your Honor, and I think that is the case because of the nature of what people do search every single day from their phones. Now, there may be very innocent or innocuous searches, such as some apparel that someone wants to purchase or looking up their friend. But there are other matters, such as researching a medical condition. It's not part of the record, but some of the amici point out that most individuals, a vast majority of individuals on their own, are going to go ahead and internet search their ailment before they even reach out to their own physician. We know that people are constantly using internet searches, private internet searches, to find out political interests. They'll look at religious views, private sexual interests. I believe that people who are using their own private device, whether it be a computer or a cell phone, a smartphone, and conducting private internet search queries, don't believe that the government can come in and look at those searches without a warrant based on probable cause.
Okay.
But you would agree, counsel, you would agree that a Google user may understand that Google is going to use that search information for its profit motive. They may sell that information to one of their partners in order to, effectuate a sale for the other partner. So,
yes.
So there is some understanding by a user of the internet that the information that you're sharing, so to speak, by doing an internet search is going to be used by Google.
Yes, Justice Donahue, that is correct, and that is addressed in the Google privacy policy, which is part of the record. And in the circumstances which Your Honor is discussing, yes, that information is provided to those other companies, so we see the ads coming up after we've searched something. But that information is relayed to those companies just for that purpose.
What's amazing? That is instantaneous.
That is instantaneous, Your Honor. Yeah, that is correct, Chief Justice Todd. That is instantaneous. And these ads do come up, and that's where it stops. That information then is not disseminated elsewhere, is not handed over to law enforcement.
Well, apparently it is, but
To the companies that are providing the advertisements, sure. But in the Google privacy policy, which discusses how that is done, the Google privacy policy also clearly establishes that private information will not be turned over to other parties absent a number of reasons. And one of the most important reasons is for an enforceable government request. And in the privacy policy, that language, enforceable government request, is in bold language. And it's our position that an enforceable government request in this situation is a warrant based on probable cause.
That returns what Justice Brobson was talking about. Why don't you focus on the reasonableness of the actual warrant itself? Because this was a keyword warrant, right?
Correct, Your Honor.
And in Pennsylvania, we've got a long and well-established history that warrants have to be particularized, individualized, and based upon probable cause, right?
That's correct, Your Honor.
Why don't you deal with those issues?
Okay, I'd be happy to address probable cause. Justice McCaffrey. In this case, the Pennsylvania State Police did not establish probable cause. The question is, in analyzing whether probable cause existed, is would the facts and circumstances with trustworthy information be sufficient to warrant a person of reasonable caution to believe that the search should be conducted and that evidence will be found? And the answer is no. This was an invalid, general investigatory warrant. There was no evidence produced in the
narrowly tailored generalized warrant. I mean, it was specific as to, the police's assumption that since this victim's home was in a remote area, somebody may have used their internet to identify where the house was located.
That's correct, Your Honor, and I agree it was narrowly tailored. It was a very specific request. There was no evidence produced in the warrant that Google was involved in any way with the planning or commission of these crimes. There was no factual nexus between the suspected crimes and probable cause in this Google warrant. That factual nexus is required, as this court noted in Johnson in 2020. In that case, the court looked at a situation where there was a report of shots fired, and the police responded to an apartment. Upon entry into the apartment, in plain view were bricks of heroin and some firearms. There were a number of people there, and appellant in that case was arrested for constructive possession of the drugs and the firearms. Based on that, the police went and applied for a search warrant for appellant's cell phone. This court said, no, just because he was in the room with the drugs and you can charge him with constructive possession doesn't mean that there is enough or a factual nexus between those drugs and his constructively possessing that to go and get a warrant to search the contents of his cell phone. Secondly, in that case, which I think is important, very important, Your Honors, in this case, is that the affidavit in that case by the police was, quote, bereft of any facts tying the affiant's expert opinion to appellant specifically. In this case, again, there was no factual nexus that I've outlined as nine factors in our brief. There's no factual nexus between any single one of them and the use of Google. I'd like to move on to those factors that the Superior Court listed and based its probable cause determination on. With that being said, and focusing at this point on Johnson and the nexus, and in that case, the affiant's attempts to tie his expert opinion and experience to the appellant, I want to focus on this affidavit. And
permit me. You said an interesting. Are you conceding that the detective is an expert?
No. No, Your Honor. No, we are not. What I wanted to point to is that the Attorney General's amicus brief relies extensively on the assertion that probable cause existed for the issuance of the Google warrant based on True Performer's, quote, experience-based reasoned judgment. The word experience does not even appear in the affidavit of probable cause in this case, which is page 173A of the reproduced record. in one sentence in the affidavit of probable cause, that is paragraph 3, where the bulk of the allegations are. Everything else is factual background. In paragraph 3, there's one sentence in his affidavit related to sexual offenders and that they are predominantly fantasy-driven. There's nothing in this related to Trooper Falmer's training in investigating sexual offenders. There's nothing in this about his experience in investigating sexual offenders. In Johnson, at least, the affidavit to some extent for the issuing authority listed why it is in the affiant's opinion that there was a connection between the drugs found and any evidence being found in the suspect's cell phone. But here, again, nothing. That just does not exist. Going back to the Superior Court's 9 factors, I'll call them as I've outlined in our brief, we've addressed there looking at 5. I'd like to look at factor 5 first. We have that note as the perpetrator was familiar with KM and her residence, possibly after seeing her in the community, and then planning the crime. So that factor, from what we can tell, the court is based on paragraph 3 of the affidavit of probable cause in the second to last sentence, which says, it is believed that the actor may have fantasized about the victim after seeing her, becoming aware of her, and it is likely that he followed her back to her address. That statement right there, Your Honors, as far as I see it, essentially negates the position that it was Google that was used and that there was a need for a Google warrant. Trooper Falmer opines that he saw her out in public and followed her back to her house.
He doesn't say that. He supposes that, or he himself, the detective, fantasized it. That's the concern that I have. Why don't we address the context?
Sure, Your Honor. It's believed. That's how that sentence starts, and that's how.
But there's no facts based for his belief other than his fantasies.
Correct, Your Honor. Yes, that's our position, that there's no facts that establish a nexus between the crimes committed and the use of Google. The other.
Counsel, let me ask you something. In order to get a warrant, do the police have to have a particular suspect in mind?
No, Justice Donahue, I don't think so.
Why is that? Why is that? Since the warrant requirement calls for a particularized criminal suspect.
I think it could be the case. I can think of situations where probable cause would exist for a warrant to Google where the suspect was unknown. That certainly is an issue here, that it was lacking in particularity, because, of course, there was no suspect. They didn't know anything about.
Well, it's the elephant in the room, isn't it? I mean, how many, when Google did its search pursuant to this warrant, how many individuals' IP addresses were captured in that net?
Justice Donahue.
15.
Yeah, it was, okay, I was going to say it was
15.
around there. Sure.
I mean, we're not talking about those 15 Google users whose privacy was invaded by the use of that warrant, but that's what happens when you don't have a particularized suspect.
Correct, Your Honor.
You capture a universe of suspects, regardless of how narrow the search is. There were 15 in this case. So.
That's correct, Your Honor, and that is certainly a concern, and it is raised extensively by our amici, and that is 100% true. If the police are given the ability to get these reverse keyword search warrants, they are going to be looking at internet search queries of countless individuals who, of course, had absolutely nothing to do with the crime at issue.
It's not uncommon for an investigation to seek a warrant to obtain information when they don't have a witness or they don't have a suspect, where innocent people are caught up in a warrant. Justice Donahue asked, let's say we don't have a suspect, but we know the crime occurred in a certain place, and we know several residents in that area have Ring video doorbell cameras. So we're going to issue a warrant to all those residents that have Ring video door cameras for their videos. I mean, that's going to capture otherwise innocent, potentially innocent behavior, but you wouldn't say you couldn't get a warrant for something like that, could you?
Well, of course, probable cause analysis we would have to conduct, but
They say no because they don't have an expectation of privacy.
well, in that case, because they were being photographed outside in public, then yes, Justice Donahue, there certainly wouldn't be an expectation of privacy. But as I was going to get to, based on your first question, Justice Donahue, in this regard, is that I can envision a situation where there would be probable cause for a warrant to Google, and I mentioned it somewhat briefly in my brief, but also a little bit differently posed here for today's purposes. Say after the attack had occurred, the Pennsylvania State Police went to the residence, conducted their investigation, mapped out the scene, and so forth, and at the scene they found a printout of the Google results that were searched by the suspect. I think then probable cause would exist to get a warrant to Google for an IP address of the person who conducted that search, okay? So I can see that under certain circumstances. But in this case, that is just not what we have. What we have here is the Pennsylvania State Police requesting a warrant for individual searches to go and get the IP address to make the connection to who the person is.
It's more akin to a general warrant.
Correct, Your Honor. Yes, we contend that this is similar to the general warrant or writs of assistance that our Constitution was.
To analogize, if you found that a crime was committed in say, a locked condominium complex and a body was found in a common area, would it be okay for the police to get warrants to search every single condominium in that particular location looking for evidence?
Absolutely not, Your Honor, because
Isn't that kind of what happened here with the Google search, the keyword search?
yes, that is our position, that a crime was committed, they didn't know who did it, so search everybody.
Like a general search, see if we can come up with something.
Correct, Your Honor. That's
Well, the
point.
facts are a little different here. This is a house that's located in a very remote rural part of Pennsylvania. The search was for a very short timeline, only with regard to this residence. And if you look upon a reasonable basis, if anybody wants to find this residence, how do people find residences or places in Pennsylvania? They Google them. I mean,
That's true, Your Honor. I agree that most people would Google, but in the affidavit of probable cause, Trooper Falmer states it's likely that he followed her back to her residence after seeing her in public. So I don't think that this warrant affidavit can be reconciled to establish probable cause.
Even though the warrant was limited to this particular address, it wasn't a give us, within a 5-day period of time, everybody in this area's IP address who searched for any address within a 2-county area. This was targeted specifically to the area of the murder.
That's correct, Your Honor, which was the target of the attack, of the rape. But the other residences in that area really, I don't think would have anything to do with a search warrant that would be sought to find a perpetrator.
So in that way,
crime.
there was arguably some particularity. There was some narrowness, to Justice Mundy's point, of the warrant. It wasn't just, we're just trying to broadly search everybody's Google history within a 2-county area to see if it comes up with this address.
Well, I think, Justice Robson, it was particularized in that sense, but on the other hand, it did go and search everybody to find that particular keyword to Google.
Well, you could say it was brilliant police work. Now,
Excuse me.
whether we're going to uphold it, I don't know.
As I said, yes, as I stated in my brief, Your Honor, it was a good guess. It was a great guess, and it worked, okay? But guessing has never been and should never be the basis for probable cause.
Well, I don't know if it was a guess. It was, it was a calculation made by the police that one of the ways, maybe not the only way, but one of the ways a perpetrator might find out the address of this victim was to run an internet search.
One of the ways, Your Honor, in our position is that that would be
Are you
insufficient for probable
Are
cause.
you conceding it was calculated or just speculated? Because I don't view this as calculated at all, but speculated, possibilities, supposition, make-believe, the basis for this warrant.
Well, Justice Doherty, it was complete speculation. It was a guess. As I said, it was a good guess.
It was a shot in the dark.
That's all.
Hit the target.
As I wrote, it was a shot in the dark, and it worked.
Can I ask a question about the issue about the constitutionality of the Google search? Do you mind if I switch back to that?
Of course, Justice.
I think we started the argument with our chief asking you about the reasonable expectation of privacy, and you described people having searches which they would obviously hoped would maintain some semblance of privacy, for example, those involved over a medical condition or such. But I'm just following up on that line that it seems to me that certainly going into a Google search on something of that nature, you would hope that it would maintain some level of privacy. But in reality, as soon as you finish the search, when your emails start loading up with remedies and suggestions for treatment of the condition you just searched, I just can't follow your path as to how there is any reasonable expectation of privacy in a Google search.
Understood, Justice Mundy. And I guess the way we look at it is that the Google search is conducted, and that information is fed through whatever algorithms to these businesses that then provide the advertisements very well. But when you're making that Google search, I don't think a reasonable person expects that law enforcement is going to be able to.
If that's the paradigm, then all the PSP needs to do is go sign up with the businesses to get the results of the searches. I mean, that's what you're arguing.
Well, I think Justice Mundy, that would ask the businesses to become agents of the state to an extent.
No, I'm suggesting the PSP go to Google and say, we went on your business list. I mean, that just kind of ludicrous.
I'm not sure how that would work, Justice Mundy. I'm certainly not a computer expert. I don't know how that would work, but.
Thank you. Are there any other questions? Do you want to sum up, or are you finished?
I'm finished, Your Honor. Thank you. Thank
All
you,
right,
Justice,
thank you.
Chief Justice Todd.
Let's hear from Attorney Skinner.
Thank you, Chief Justice Todd, Justices. I'm here on behalf of Northumberland County District Attorney's Office. So I will start with the Google warrant because if there was probable cause, it kind of it makes the other points moot. However, I do think those are also important to address because they are issues that we will see once over and over again. So looking at Google specifically, Google is so fundamental in our everyday lives. It's even a verb that is in the dictionary now, but Google is a quick source for answers to general questions, where directions are, and it can even give you those directions. When you provide information to Google, it is able to reach out throughout the internet and bring you back targeted responses to your searches. Looking at the warrant specifically, you need to establish a nexus using keyword searches. So when you're using your keyword search, you're not getting
Now,
every...
Can I interrupt for just 1 second? To your knowledge, has Pennsylvania ever addressed the legality under Pennsylvania's Constitution of keyword searches?
To my knowledge, Your Honor, I was not able to find any addressing of that constitutionality.
Have you done any research on whether or not any other jurisdictions have dealt with the applicability or the legality or constitutionality of keyword searches, or even a geofence search?
So there's a lot of federal case law. Other jurisdictions, Colorado did have a case, People versus Seymour. They deemed that there is a private expectation of privacy in the keyword search. However, the differentiation with Colorado law and our law is that in Colorado they do not recognize the third-party doctrine. They conceded within that opinion that yes, federally this is a long recognized precedent, that there's no expectation of privacy in the Google search. And in that case, they did recognize that the keyword search properly had a nexus to the crime that was committed, and they ultimately upheld it because of good faith.
This court has also not recognized the third-party doctrine as of right now, has it?
No, Your Honor. But looking at what Google is, this is an anonymous internet company that you're providing information to. You're sending information to someone unknown who then further distributes this information elsewhere to gather your information. So expect... Yes.
Counsel, I apologize, but with regard to these Google searches, you're familiar that you can do a regular search or you can go into this private mode,
Yes.
correct?
Yes, Your Honor.
So share with me, what's the concept of having a private mode if it's available to law enforcement? Doesn't that contradict your theory?
So the private mode, I think, has further protections offered through the company. So we're looking at what the company says within their terms and conditions on the website. So if you're using a general search, you're agreeing that that company is free to distribute your information to whoever, provide your results, continue tracking with your IP address. When you're looking at a private mode, there's some more enhanced security where you might be able to restrict cookies or other information that the company accessed. And so if you want a further level of privacy, utilizing a privacy mode would be a better way to restrict access from other companies, a more secure way to search. But if you're using general Google, that information is just available.
Was this search a general or a private?
It was a general Google search.
So can I ask another question? I don't mean to monopolize this. I promise this might be my last one. Why does law enforcement need a warrant? Why couldn't they just go to Google and say, hey, we had this situation that happened in Pennsylvania, in Northumberland County, where a woman in a remote location, we think the person had to Google her. Why do they need a warrant? Because warrants in Pennsylvania, as I mentioned at the outset, they have to be individualized, particularized, based upon probable cause. That's the law. In this particular case, we seem to have cast a fishing net looking for somebody that Googled this woman's address. Would it have been permissible for them to just go to Google and say, did you have anybody look it up? I mean, no different than if you went to a librarian to see whether or not anybody took out a book on this woman's address.
Correct. In theory, yes, that could be how it's done. However, under the Wiretap Act, I believe if we're seeking records or any information from an internet company, we do have to provide a search warrant. But additionally, Google themselves requests a search warrant. They request a legal process from that state, and they will honor it as a
imposed by Google, not necessarily by, okay.
Yes, Your Honor. So, and then once they receive that, they review it. And in this case specifically, we did submit 2 warrants to Google. They deemed one to be too broad, and then the second one was the one we received the response to. So within the warrant, the keyword warrants help establish the nexus to the crime. You're able to gather a location. You're able to use a location, information about the crime, the totality of the circumstances to build your probable cause. Because a search warrant isn't just for an immediate arrest or crime or evidence from the crimes that are immediately there. It's also for investigative purposes, to confirm leads, to develop a suspect. So those are other methods in which you can utilize the warrant. When you're receiving your results, you're not getting a full background biography of every search this person has done. You're getting specific IP addresses targeted to specific keywords that are relevant to the specific crime. So at the case at hand, specifically the victim's address and her name, and there was only 15 out of billions of users that searched within a very specific tailored time period to the crime.
It's kind of concerning that 14 other people were Googling her address also, isn't it?
It is.
And that you access billions of other people's information in an attempt to narrow this down.
I am not sure how the algorithm was conducted through Google, but I based that off the users that potentially use Google. I'm sure that varied within the time frame.
Counsel, probable cause requires objective facts, not subjective facts. And a police officer, we all know, needs more than just a hunch or a speculation. Can you share with me in the affidavit where is the objective facts? Because it appears that paragraph 3 is his subjective belief based upon his understanding of fantasies and victims. Share with us in your argument that this is a valid warrant. Where are the objective facts? Can you point one sentence out to me that's objective?
I think the objective facts would be the remoteness of her location and the unknown identity of the perpetrator. We have an individual who went to a house where nobody knew where it was, and officers required Google to get to that residence. Officers that worked in the area for an extended period of time.
It's believed that the actor knew that the victim's husband was not home at the time of the entry into the residence. What? Tell me, where's that objective fact? What is this? What this really is the police officer realized that he Googled or he knew who the victim's husband was, who works as a correction officer, and he probably did a lot of research on the correction officer and saw that the defendant had a prior contact, and then made this up to get what he believed. But that is as much speculation about how the detective acted as the facts that he based upon in his warrant.
Well, there's absolutely no basis for that, no basis that he, had some ulterior motive for it.
That's exactly my point. What is the factual basis, all the ulterior motive? It's just as commonsensical to think that he set up this guy as he did for these facts, that he knew the husband wasn't home. That's outrageous. So what we're now condoning is law enforcement can come in with supposition and invade someone's privacy and the sanctity?
No, Your Honor, I'm not trying to suggest that at all. What I'm suggesting is looking at the totality of the circumstances and things about the crime that the trooper thought was weird.
It's in there that the husband wasn't home. Give me an objective fact for which that's based.
I don't think you can, because you don't even have a suspect in this case. This detective was, what we have here is either a violation of privacy rights, or we have some Kojak-level great police work.
Yeah.
Because this was really a shot in the dark that hit the target. 14, 15 people come back, they look at the one guy, what's his name, Kurtz? And, oh my God, Kurtz is a corrections officer, works with her husband. Boom, he's now your suspect, right? They didn't follow the other 13 or 14 people.
But they could have.
They could have, for sure. But they catch them, they throw the cigarette out, they get the DNA, and bang.
Well, and part of the process to identify him as well was when the IP addresses are received, they have to be run through ARIN, the American Registry of Internet Networks. And then you get a company, the company that owns the IP address. Once you get that company that owns the IP address, you then have to do further legal process, which was another search warrant, submit that to the company, who then finally provides an identifier. The search warrant didn't provide the name. A Google warrant is not providing the identity of the person that did it. You're provided with the IP address that is owned by this company, who then gives you the subscriber information if they still retain it on file. So once the legal process was submitted to identify the people that did conduct the search, not every company even retained the IP address information for those people because the records were too old. So just so happened in this case, the company in which the defendant used actually had the records. Comcast did not, other companies did not. So the results that we received, there were several layers insulating this person's privacy, this individuality, before they even became a known name to the Commonwealth. And looking at the totality of the circumstances, I think it wasn't so much as a shot in the dark as just how else would this have been done if this was not utilized? Because we needed to utilize it to get here. Somebody not familiar with this area would have to do the same thing. This is not somewhere you just stumble across. This is not somewhere you find.
But the affidavit said that they believe that the suspect followed her home. He knew where she lived. Why are we doing a Google search for her address? The affidavit itself presents an internal problem in terms of why they needed the Google search of her residence. Well, he knew where she lived.
Correct, but there's also other information, too, that would be accessible through Google. Does she have any children? Are there any other individuals in the home that they did not see at a time they followed them home?
That's what they asked for, though. They asked for her name and her address. Information that the suspect, whoever it may have been at this point in time, apparently had, according to the affidavit. So, I just don't understand how that supports doing the Google search.
So focusing on the victim is the best way to get the narrowly tailored results that we are looking for, to have the particularity within the warrant, because if we just searched a neighborhood or anything like that, we don't know the relation of those searches to our victim. But what we did have was this specific individual was the victim of a crime at her residence. So we focused on that. And that would be how you make that nexus with the Google searches, because you're able to then gather the other information you want. Whether he did follow her home or not, there's information that individual couldn't get at that point looking at her and observing the area, and, you know, it's more convenient, realistically.
Now, in the affidavit of probable cause, that was a possibility cited. He may have followed her home.
Yes, Your Honor, and that's going along with, you know, theories about these sexual predators.
That's exactly, the chief just hit the point. That's a subjective view, and probable cause requires objectivity. Can you share with me, where is the objective fact that he followed her home, that he knew who she was, and knew the husband wasn't home?
Within the warrant, specifically to that line, there is nothing objective surrounding that specific line.
But that's the basis for the final paragraph, asking for the warrant of Google of the IP addresses. So if you concede that there's nothing in the preceding paragraph, which is the substance, allegedly, of the objective probable cause, and there exists none, which means the warrant is insufficient because it's based upon subjectivity, not objectivity, and it's just clever police conduct, but not legal in Pennsylvania.
I think looking at the entire context of the warrant and viewing it in totality of itself, not focusing at it line by line, but focusing on it as the victim's husband was not at home at night, which to most...
How do they know that? How do they know that? It's believed, not there's nothing in this four corners of this probable cause that indicates the husband, who he is, what his occupation is, or what the hours of that occupation. Other than the detective, prior to drafting this, knew who the husband was and knew he worked at night as a CO. But he didn't put that in here. Maybe he put that in. That would be objective facts. But there's nothing. And again, you said reading that particular line. I'll ask you one more time. Maybe I'm misunderstanding you. Point to paragraph 3 and give me one objective fact.
I feel like looking at it paragraph by paragraph and not in the totality of all the circumstances that were known, the beliefs, because of the nature of the crime, does not give the full understanding and the full basis for the probable cause. Looking at one individual section by section, that might not necessarily fully support the probable cause. But it's...
Let me try to help you a little bit, although I'm not sure it helps you. But the only objective facts that you just indicated, in the course of this discussion is, you know who the victim is. You know where the crime occurred. Those are the two objective facts you have. And you believe that the Pennsylvania Constitution allows for police officers to use simply the location of the crime and the victim to get a Google warrant.
I think under the circumstances in this case specifically, yes, but not necessarily every case.
Well, that brings us back to Justice McCaffrey's question earlier. Did they need a warrant at all?
Our argument is no, because the information that we received back was an IP address that is similar to an email address or an address on an envelope. It is a assigned number that you receive from an internet service provider that you then send out into the internet to wait and receive information back to you. It is an address that is used in a way to communicate with you. It is not an identifying number and is owned by this company that assigns it to you. And even with the search queries, the information we received back, we did not get virtual biographies of these queries. We received information from Google that these IP addresses requested this information, and that was the extent of it.
All right, are there any other questions for Attorney Skinner? Well argued by both. Thank you. Thank you so much. Mr. Minner, would you call the next case?
Kleinbard, LLC versus Office of the District Attorney of Lancaster County, representing Kleinbard, Mr. Kurtz, representing the counties, Mr. Mark Brash.
In this appeal by allowance, the former Lancaster County District Attorney entered into a contract with appellant Kleinbard, LLC, to represent him in his official capacity in a lawsuit against various state and county government individuals. The Lancaster County Commissioners had appropriated $5,000 to the District Attorney's Office for legal fees. However, the DA incurred over $74,000 in legal fees in connection with this lawsuit. The DA sought to pay the legal fees, which exceeded the $5,000 appropriation, from program accounts run by the DA's office, which were funded by program participants rather than by taxpayer dollars. We must determine whether the DA had the authority to do so under the county code. Good morning.
Good morning. Madam Chief Justice and Justices, may it please the Court, Francis Notariani on behalf of Kleinbard, LLC. I'd like to start by noting that we're here on preliminary objections because it's weaves through the arguments, and it's something that the lower courts failed to appreciate. When the well-pled averments in Kleinbard's complaint are accepted as true, it's clear that District Attorney Stedman never attempted to exceed the legal appropriation line item in his budget. He identified on his voucher form 2 non-appropriated program accounts from which he intended to pay Kleinbard's legal bill. Against this factual backdrop, the Commonwealth Court's errors are clear, and this Court should reverse for at least 3 reasons. 1, the panel's holding is inconsistent with Section 1773B's plain language. 2, the panel's holding is inconsistent with the holding in Yost versus McKnight. And 3, the panel's decision engenders a separation of powers issue. To my first point, Section 1773B of the County Code applies only to appropriated money. It's titled Supplemental Appropriations and it involves moving appropriated monies within accounts and among row offices. A district attorney's use of non-appropriated money will not cause the sums appropriated in his budget to be exceeded. Here, District Attorney Stedman identified on a voucher form to pay Kleinbard's bill 3 accounts from which the money was to be drawn. One was a line item for legal fees that was appropriated by the county commissioners, and 2 other line items were, or excuse me, 2 other accounts were the program accounts, the Drug and Alcohol Rehabilitation Program and the Bad Check Restitution Program. Those.
Counsel, let me ask you a question. As to those last 2 accounts, what's your legal authority for the proposition that those funds were for the discretionary use of the district attorney?
Well, we're not aware of anything that says the district attorney does not have discretion over those, and we're not aware of any authority that puts those monies within the discretion of the county commissioners.
But isn't that the heart of your case? I mean, that's not a factual question. That's a matter of law, whether or not the district attorney, in fact, has control over those funds.
I think it's a fact-laced question. There's certainly a legal component to it, but we don't know, for example, whether there's an agreement between the county commissioners and the district attorney for how these funds are supposed to be used. We know, attached to the complaint, at reproduced record, page 316, there's an email from the current district attorney that says these accounts had been used in the past from anything for office supplies to donations to nonprofits. So it seems that the district attorney has discretion over these funds, and with more factual development, I think we'd be able to identify the exact contours of that discretion to the extent it exists.
Take, for example, the situation with the forfeiture account. There's a specific statute at play that says precisely what happens to funds that are acquired forfeiture proceedings.
Yes, Justice Donahue.
I mean, what's the theory here, that this is potentially a slush fund for the district attorney's use?
You can call it a slush fund, but just because there's not a statute authorizing the creation of these programs doesn't mean that, again, that they're prohibited. The district attorney entered into a contract with third parties to provide these services to their constituents, and his office generated revenue. We don't know the facts around, the contract with the third party or how, the district attorney and the commissioners have agreed to use these funds.
You haven't played that. Is there, I mean, it was striking to me, at least in your pleading, and even in the briefing, the Commonwealth Court, no one attempted to flush out what these generic program funds are. I think it's a highly relevant fact that probably should have prevented the Commonwealth Court from sustaining the POs or granting the relief that it granted, because your case really simply boils down to, as Justice Donahue said, is who controls these program funds? If they're not funds that are part of the county appropriation process and are within the sole discretion of the DA's office, you might have a case. If, however, they are funds within the power of the county to appropriate and they weren't appropriated to you, you probably don't. Don't we have to send this back for some sort of factual development that nobody seems to want to give as to what these program funds are?
I absolutely agree, Justice Robson. And again,
well, yeah, you agree, but why? I guess I'm trying to understand is why are we hiding the ball here?
Yeah, but you don't agree, because your argument in the lower court was that this was a well-pleaded fact that had to be construed in your favor. I mean, that's why there was no attempt at discovery here. It's because you said you have to accept that it's true that this money belongs to the district attorney for the district attorney's use.
well, I think both could be true. We believe it's true, but to the extent, more factual development is necessary, then we deserve the opportunity to seek that and to have that. And I think it's notable that
I think to your point, though, I mean, just if I can interrupt for a second, that's not the reason why the Commonwealth Court booted you out. The Commonwealth Court booted you out simply by saying you've only been appropriated $5,000 for fees, and therefore, if that your client, the DA, was only appropriated $5,000 for fees, so the DA can never incur or be obligated to pay more than $5,000. It really was not even. That's a pure statutory construction question, I guess. If the Commonwealth Court had said something like, we're sustaining POs or dismissing you because you haven't pled necessary facts, i.e. you have not identified what these funds are, then that would be a different way of throwing out the case, wouldn't it?
yes, and again, in the commissioners, they haven't PO'd on the basis that the pleadings weren't sufficient enough factually, and they've never taken a position on the discretion of these funds. They never even addressed the funds in their preliminary objections. Their sole argument was the same as the Commonwealth Courts, that District Attorney, you have $5,000 appropriated to you, and that's it. You can't do anything else.
So shouldn't we allow this matter to go back to the Commonwealth Court to basically engage in discovery again to see historically, if you're saying these are discretionary accounts, the DA can use these funds for whatever he wants to use them for? Shouldn't we allow some discovery to see historically what he's used them for, or what she's used them for, the District Attorney?
Yes, Justice McCaffrey. I think that's fair. I think it's the only way to determine the discretionary contours of these funds.
I think we've all taken a look at it. There's no enabling statute for what these programs were set up for, what the money's used for.
But we don't even know what they are.
Correct.
We don't even. I mean, you call them program funds. What are they?
Right.
Drug and alcohol funds. I mean, I don't even.
Bad check funds.
Yeah.
What authority does the district attorney have to raise revenue for its own use? I mean, that's just not an executive branch function.
I note that the commissioners are not challenging the creation of the programs. They've been created by contract before this dispute ever existed. And the district attorney's office has been generating revenue from those accounts for a while now. I think we just need more factual development to figure out what's going on and how these funds are being spent. And just because there's no statutory authority authorizing the creation of the funds doesn't mean that they're prohibited in any way.
Well, and as the appellant, what are you asking for? What are you asking us to do?
To remand it to the trial court to have discovery and to learn more about these programs.
Fair enough.
All right. Any other questions? Thank you.
All right, thank
Mr. Natarani, let's hear from Mr. Bradshaw.
Good morning. My name is Mark Bradshaw, Madam Chief Justice, members of the court. My name is Mark Bradshaw. I'm from Stevens and Lee, and I represent the Lancaster defendants here. I want to return to the way the case was described initially, because I think there's one particular fact that drives the outcome here. And in the description What Madam Chief Justice said was that $74,000 were incurred. If you look at the complaint, which is paragraph 21 of the complaint, reproduced record 15A, $100,000 was incurred. Now, why is the distinction between $100,000 and $74,000 important? Well, if you look at the Yost case, what the Yost case, which I think both parties have briefed exhaustively and the Commonwealth Court focused on, what the ill is that is described in the Yost case, and I can read the holding for that matter, is the possibility that the contract that is entered into will cause the amount that is expended to exceed the appropriations. So Yost says, and I'm quoting here, forcing the payment of such contracts could potentially overdraw the amount the commissioners have budgeted for the department, or cause the commissioners to appropriate funds from other line items or other departments and levy taxes, etc., when those excess monies might be needed for some other purpose in the county.
But that begs the question that we just asked Mr. Natiriani, which is, we don't know what these monies were for in the discretionary accounts, because Yost stands for the proposition that the executive can use money for those services for which he has funds in his budget. So we have allocated budget monies under 1773. If these monies were neither allocated nor budgeted, why couldn't he use them for some other sort, from some other reason, like to pay his attorney's fees?
Because the county code prohibits reallocating things from one line item to another.
But it's not a line item, it's a separate budget item. We're trying to figure out where these programs were created, funded, and what the money historically has been used for, right?
Here's my response, and frankly, there were questions from all of you, and so it is not merely a response to your question, Justice McCaffrey, but the response to all the questions that were asked earlier. I don't believe there's any discovery that's necessary. I think you know everything you need to know about these program accounts from the record that's already been established. So the two program accounts have names. And the names are the drug and alcohol diversion account, has nothing to do with legal fees, and the bad check restitution account, which again has nothing to do with legal fees.
How are those programs created? Is there an enabling statute?
The record is silent on that, and what is remarkable to me is...
How do we have the information that we need then?
Well, what I was about to say was that you have all the information that you need in the sense that these are public programs that have obvious purposes, drug and alcohol interdiction and bad check restitution, that have nothing to do with the district attorney's legal fees. And frankly, the other thing that I want to respond to before I move on is the suggestion that the district attorney has unfettered discretion over these funds. That's simply refuted by the record that's in front of you. If the district attorney had unfettered discretion over the use of these funds, he would have opened his desk drawer and dispersed the funds as he saw fit. But he didn't. He had to make a requisition to the county controller. The county controller was answerable to the commissioners, and the commissioners said, absolutely not, as we told the Kleinbard firm way back when this dispute started, we are not responsible for these fees, we will not be responsible for these fees, and we are not going to pay this.
That's definitely coloring what I think is a little bit simpler than that. These were POs.
Correct.
So we're on a PO posture, and the decision was based simply on the notion that the voucher that was submitted to the controller sought a payment in excess of the appropriated $5,000.
Correct.
That's the sole legal basis for which this was supposedly thrown out. Mm-hmm. And I could see it the other way, too, which is, according to them, no, we never asked for a distribution of appropriated funds in excess of $5,000. Our voucher did not seek a distribution of appropriated funds in excess of $5,000. We sought our $5,000 line item as appropriated, and now we want the controller to release funds that are purely within the discretion of the district attorney to spend. That's their point. And I appreciate the fact that you're telling us that we know what these funds are, but we do and we don't. You're saying they didn't have the discretion. They're saying they did. But your argument the ruling, it's the actual ruling that's in front of us that I'm struggling with. So, for example, let's say the county commissioners appropriate to the County Board of Elections $100,000 for purposes of upgrading to election voting machines in the county, and that's all they appropriate. But the Bill and Melanie Gates Foundation give an extra $150,000 to the County Board of Elections to augment that. If the county court's decision here stands and the Commonwealth Court's decision here stands, they could never get access to that fund. They would be limited to the $100,000 appropriated by the county commissioners because the other $150,000 is in excess of the $100,000 appropriated. That's how I read what the Common Pleas Court did here. Why am I wrong?
I think the distinction is that in your example with the Gates Foundation making the additional appropriation, or the grant, if you will.
Gift.
The gift, the grant, the county commissioners would acknowledge that that money had been set aside for that purpose, and it would be spent for that
That's
purpose.
not the question. The question is, do they have to? Do they have? And that's the legal issue that the Common Pleas Court and the Commonwealth Court did not tackle, which is, what is this other pot of money, and is it something that has to be appropriated by the county or can't be spent at all?
That's true, and frankly, if that's what the court is concerned with, the record is insufficiently developed to answer that question. What I keep coming back to is the language of Yost, which is, I mean, what we're talking about here, and both the trial court and the Commonwealth Court focused on this issue and this issue alone, and that is, the issue is not whether he has access to other money. The issue is whether he has the legal authority to enter into the contract in question.
Counsel, correct me if I'm wrong. Yost is distinguishable because when the DA of Clinton hired Joe McGettigan, a former Philadelphia DA, he did it he hired him as a special prosecutor, but he never sought to discretionary funds. He was contractor pursuant to the general fund allocation. That's completely different and distinguishable from these facts in which the DA is now looking at a discretionary fund, correct?
Well, you're correct in part. In Yost, the money that was spent for Special District Attorney McGettigan was available in the budget from the allocated funds. So the narrowest reading of Yost is that the district attorney has the authority to spend the money that is already in his budget. But the broader implications of Yost and the language in Yost says that the converse is also true, and that is that
the commissioners can tell an executive branch how it spends its money?
The commissioners can tell the executive branch how to spend money that is specifically allocated in the budget. So what we have here is a specifically allocated line item for legal fees, $5,000. And the district attorney goes out, and I want to return to this. I began down this road, but I never finished my thought. The contract amount, and this is the Yost problem, the contract amount was $100,000. And so what we now have before you is Kleinbard saying, well, we're only asking for the $74,100 and whatever the sum is, it's pleaded, that is available, consisting of the $5,000 that was allocated and all the money that's available in the program accounts. That's not what the contract was for. The contract was for all the legal fees incurred in pursuing the underlying action, and I want to come back to that as well, but one thing at a time.
Let's freeze right there, Counselor. But are you sharing with us that despite this is a contract between the district attorney and the law firm?
Right.
Now, it's your position that any expenditure from the district attorney's office must be submitted and approved by the commissioner, any general fund allocation?
No. To the extent that this was $5,000 or less, the requisition would have gone to the controller, and I don't believe that the county commissioners would have had any ability or authority to question whether or not that was
So help
properly.
me understand. So this DA program, is that a line item in the general, in the commissioner's budget? Or is that a separate account for which the district attorney deposits any monies received as a result of these programs?
The record is unclear on that point.
And does the record indicate whether the approval of the commissioner is required before the district attorney dispenses or disposes or encumbers monies on an account exclusively within their discretion?
Well, I have to challenge the suggestion that it's exclusively within the district attorney's discretion because, again, the requisition had to go to the controller, and the requisition was refused. And so, once again, I think the record in front of you so far does demonstrate.
Just because the controller refused it doesn't mean the controller properly refused it. That's
why we're here.
That's what the lawsuit is about.
That's why we're here.
Permit me to take this to a logical extreme. The district attorney holds a bake sale, and they make thousands of dollars. Does the controller have the right to tell the district attorney how he or she can spend the bake sale money?
Well, it's funny that you mention it that way because I actually had thought about raising a bake sale as an example before the court. I would say that the answer to that is probably no.
What if you had a situation where a lot of criminal defense attorneys showed up at the bake sale and started paying a couple $1,000s for a donut?
That would certainly be problematic in my view.
A little bit of a conflict?
Mm-hmm.
Yes. I mean, the point here is, and this is the Yost problem, the reason that the law firm was seeking only $74,000 when it incurred $100,000 in legal expenses is because that's all the money that was available. So the balance between the contract amount, $100,000, and the available money, the $74,000, would necessarily have to come from taxpayer funds. And what that means is...
But is there an allegation that they want money in excess of the monies in the account?
No, but the point is, did he have the authority to enter into the contract? And the explanation for that is no, because if you honored the contract, you would necessarily have to expend additional taxpayer funds.
Well, no,
that's the significance of the delta.
You're conflating a whole bunch of stuff. I mean, if I have a contract with you that you're going to pay me $200,000, I can say I only want $50,000. You can have contracts that have a certain lawyers can compromise their fees to accommodate the ability of their client to pay.
Well, that's true, but what is happening here is a deliberate, in my view, a deliberate attempt to disguise the actual nature of the contract, because if you acknowledge the actual nature of the contract, which is that it exceeds the budgeted amount,
well,
even with the program funds.
Why does that matter if the parties only intend to seek a permitted payable amount?
The way this case was analyzed both by the trial judge and by the Commonwealth Court was that the pivot on which the case turned was whether or not the district attorney had the legal authority to enter into the contract in excess of $5,000.
Based on the view that the DA only had $5,000 accessible of appropriated funds, in that there was no other funds available.
Based on the view that the commissioners had only authorized the district attorney to spend $5,000 on legal fees.
Only appropriated $5,000 on legal fees. The word
right,
appropriated is in the statute.
I see the two as functionally equivalent in this context. So what I wanted to do is I wanted to come back to one other point, which has to do with the fundamental problem here. The $100,000 that this particular law firm is seeking to recoup from the county were incurred in filing a lawsuit in the wrong court. So if you go back and you look at the underlying case, which, by the way, is reported, it's 221A3rd 747. This was the original case having to do with the district attorney's use of drug forfeiture money to lease himself an SUV, which touched off the entire dispute between the parties here. What happened was Kleinbard wrote a letter, it's in the record, it's two letters, 86A and 90A, back-to-back letters insisting that the county commissioners stop publicly addressing his use of the drug forfeiture money to lease the SUV. And he was told, his lawyers, Kleinbard, expressly told the county commissioners, if you don't shut up about this, we're going to sue you. It was very heavy-handed. In fact, the second letter found at page 90A says, it's been 36 hours since my first cease and desist letter to you. You haven't ceased and desisted. You haven't responded. We're going to sue you.
This is all very interesting, but what does this have to do with the case before us, Mr. Bradshaw?
The source of the $100,000 in fees that was incurred was in the pursuit of a case that was filed in the wrong forum. So there was no public benefit whatsoever to the fees that were incurred here.
That sounds like a good defense by the county or the district attorneys or a cross-claim for professional malpractice. But I don't know how that has anything to do with the simple question of whether the district attorney, if he or she has access to other funds that do not go through the county appropriation process, can augment a $5,000 appropriated line item for league fees with those funds. That's really what this suit is about.
I will admit that the point that I'm making now does not go to the heart of that particular issue, but my point really is this. This court really ought to have very little sympathy for this law firm under the circumstances of this case. When you look at why the lawsuit was filed in the first place, where the lawsuit was filed, the fact that the county expressly said we are not going to pay these fees before the fees were incurred, the fact that there was just an absolute obstinate insistence on staying in the Commonwealth Court in the first place, that's where the $100,000 got incurred, and the fact that under the Pittsburgh baseball case, a party contracting with a government agent is responsible for doing their due diligence and understanding what the limits of that counterparty's authority to pay fees is.
Counsel, let me ask you another question about this drug and alcohol diversionary program and the bad check restitution program. Are these programs that exist in any other county? Are these statutorily based programs, or is this something that was in the imagination of the former district attorney?
The record is silent on that point, and I'm reluctant to speculate, although it is my understanding
well, it's a question of law. Is there a statute
Oh,
that authorizes
not
these
that
programs?
any party has identified in any of the proceedings leading up to today.
And your clients did not challenge the legality of any of these funds?
No, there was no challenge to the existence of the programs. The challenge was to the attempt to utilize the proceeds of the programs for this purpose.
So you didn't say that, you didn't argue that they were illegal?
No. No.
And you know, counsel?
Yes.
Although you don't know where these funds are housed within the county accounts, you know precisely the amount of dollars that were generated. So how is that? You know, but you aren't going to tell us, or
No.
are they is it a line item within the budget of the county after the funds are generated, or what?
Again, and I assure you I am not attempting to be coy with the court. The record does not reflect that, and I do not know the answer to the question.
But you know it's $74,822 or whatever the...
Well, that's what's pleaded.
But you know that it's pleaded because that's the amount that is housed somewhere in some account in the county that was generated from these two programs.
Correct.
All right, would you like to sum up, sir?
Certainly. The one issue that really troubles me about this case is that there is, on the other side of the aisle, apparently zero interest and zero recognition of the public interest component here. So what we do know merely by the title of the program accounts is that they are for the benefit of the public. Drug and alcohol interdiction, bad check restitution. It has nothing to do with legal fees whatsoever. And so if you look at the budget of the county holistically, I would, and this is speculation, but I think it makes sense. If the district attorney is permitted to raid these programs to supplement his legal fees allocation, would not the county commissioners then reasonably say, but those are important programs that serve a public interest, so now we're going to have to go back and allocate dollars to refill those buckets. Where do those dollars come from?
But counsel,
tax dollars.
The county doesn't supplement discretionary funds. They're drawn from service charges caused by the Commonwealth, caused by the district attorney's office in its application of a program. Hypothetically, you get into my drunk driving program, you got to pay me $300, of which I'm taking $100 and putting into my account as the DA.
We're not looking to incentivize district attorneys to sue the county commissioners. But if these are funds that are exclusively raised by the district attorney and used discretionarily, and that's why we went back on this before. If these are discretionary funds that are raised by the district attorney and they have historically been used for other purposes, what's to prevent them from using them for legal fees in this particular case? And I'm begging the question because we don't know the answer to any of those questions, the most pertinent question being that question raised by Justice Donahue. What's the enabling statute? I mean, what gives the district attorney the right to A, create these programs, and B, charge individuals caught up in a drug arrest or a DUI arrest a surcharge to get into the program? So we don't know anything about the program itself, the historical use of the funds, whether or not there's any guardrails on the use of the funds.
Right. The short answer to that question is that even at this stage, standing here in front of the Supreme Court, no one has ever identified a statutory basis for these programs. They just are.
All right, that was very well said,
Thank you.
well argued. Let me ask Mr. Notarianni, was this your first appearance before the Supreme Court?
Was that obvious?
No. Only by your apparent youth. So it was a good experience? All right. We'll come back again. Thank you, counsel. We're going to take a lunch break at this time, and we'll resume Mr. Minner at about 12:30. of an individual to situations where the involuntary commitment was initiated by written request bars this particular lawsuit. Please proceed.
Thank you, Chief Justice Todd, and good afternoon, Justices of the Supreme Court. May it please the Court, Maureen McBride for Alley Medical Center, David Go, MD, and Kyle Mazza. With me today is my associate, Andrew Stafford, who was very instrumental in helping with the brief. Your Honors, as Chief Justice Todd explained, we're here today to ask this Court to reverse the decision of the Superior Court and to grant summary judgment in favor of the defendants on a Mental Health Procedures Act issue. The narrow issue in the case is whether the Mental Health Procedures Act applies to create a cause of action here. Importantly, this is a third-party claim, not a claim by a patient, but a claim by a third party that there's liability under the Mental Health Procedures Act. This is a circumstance where the prerequisites under the MHPA have not been satisfied. So this is a pure issue of statutory interpretation. The question is whether the healthcare providers, and Alley Medical Center is a walk-in clinic. It's not a hospital. It does not do inpatient care. But the question is whether the providers participated in a decision that a person be treated or examined under the Act. If not...
Just treated, correct?
I'm sorry?
There's a difference between voluntary and involuntary. For voluntary, it's just a question of treatment versus examination and treatment.
So with
as the statute reads, which I was going to ask you why that is.
So with respect to voluntary, and this is what we're talking about, so Light was involuntary inpatient. This is voluntary inpatient is the claim. Our response is that this is outpatient until the threshold requirements are met. So the question is whether, to answer your question, whether the prerequisites have occurred. There are a number of prerequisites before you get to issues of examination or treatment.
Can I just stop you there one more time? That's what I'm hung up on. When there's a question of voluntary commitment,
right.
It's not examination and treatment that triggers the immunity / cause of action. It's just treatment versus involuntary commitment, which uses the phrase examination and treatment. And I'm wondering if you know why that is.
So I believe that you still need to perform an examination with respect to voluntary inpatient treatment.
I understand. That's why I'm asking you about this, because if you read 114A, it says in the absence of willful misconduct or gross negligence by an authorized actor who denies an application for voluntary treatment or for involuntary emergency examination and treatment. And I'm just wondering why the distinction. There must be one. I'm just not familiar enough with the processes to understand why there would be that distinction.
Well, I think because you can examine the person perhaps in the involuntary situation, they come pursuant to a certification from a doctor or a warrant. If a person is presenting for voluntary inpatient treatment, they have to do it pursuant to, and this is where we get into the prerequisites, an application which requires it be in writing. And that is because it's subject to 18 PS 4904, which is unsworn falsifications to authorities. That requires that it be in writing because that statute only applies to documents or tangible things like maps. So that's the first indication that the application, and it says all applications, this is under the statute 1710, must be made subject to the penalties of 4904. So that's the first reason it has to be in writing.
Ms. McBride?
Yes.
Who controls the application process?
I'm sorry, I missed the first part.
Who controls the application process? Here's my concern. We seem to be imposing a fairly stringent burden upon individuals who are suffering from a mental health crisis, homicidal, suicidal ideation. And upon those, we're saying to them, you have to know about the application process, request an application, and complete an application before you're going to be subject to the Mental Health Procedures Act. So that seems to be your argument.
No.
So I want to know who controls the application process, and why are we imposing that burden on them?
So the burden is not you have to come to the facility with an application already completed. These applications are available online, but pursuant to the regs, which the General Assembly directed DHS to create regs and forms, and they must be this form, and it must be in writing. And those forms are available, I presume, at facilities. Certainly, I know that a hospital like Geisinger would have them. And then the statute requires, and this is why it gets into the issue. The issue really is whether the statute attaches, whether these threshold requirements have been met. Not everybody who says the words, I need some mental health, automatically falls within the statute and therefore has a cause of action that can be created. And again, to put it into context, the whole purpose of the Mental Health Procedures Act, I mean, there are two main purposes. One was to increase availability of mental health services, and the other is to put people in the least restrictive environment. So these were created to limit liability, to create immunity for healthcare providers, not to expand liability or create new causes of action.
And I don't disagree with you. I think that's the purpose behind it. I think, though, to Justice McCaffrey's point, when it comes to presenting yourself for voluntary inpatient treatment, the only thing you need as a healthcare provider to protect yourself is the application to the extent it indicates this is voluntary. Correct. That's all you really need. And that's really what the application, the form that was created, does, is to just document the fact that it's voluntary. Why does that have to be filled out before the decision is made whether this person needs inpatient treatment? Why can't it be something you present yourself to a hospital, you seek voluntary inpatient treatment, the medical provider makes a determination about whether it's appropriate or not and says, yes, now, here's the form you need to fill out so we document this is voluntary?
Well, because, again, the statute itself says that it has to be an application, it has to be in writing. And then
my scenario gives you an application.
You have an application, but also then there's an evaluation, and I think you alluded to that it has to be a determination as to whether these mental health services are both necessary and appropriate.
And then that determination, you will only be held responsible for a misdiagnosis or bad decision if it was grossly negligent or reckless.
Well, you still have to complete that on the form. You have to get
What's the point of having somebody fill out an application if you've already been denied or you're going to be denied?
Well, I mean, this patient had been previously denied at Geisinger, came to our facility.
Let's just stick with Geisinger.
Okay. Well,
what's the point? The person presents at Geisinger, asks for voluntary commitment. Nobody says, hey, you need to fill out this form first. They just say no. What's the point at that point in time for this person to say, oh, well, can I have the form now so I can potentially sue you for gross negligence?
Well, I understand that, but again, and I've listened to the arguments all day today about statutory construction. I mean, this is the language of the statute says that all applications must be in writing subject to this. And this court in Light made clear, and I think the policy arguments in Light apply, of course, with equal force here. Otherwise, we are in a statutory gray area. We have people who are on the front lines who are dealing with patients who don't know if just contemplating if the person says some word that suggests that the person might be asking for mental health services, that suddenly the statute applies, a cause of action is created, liability attaches.
Maybe the people on the front lines should say and should know from the statute, based on your argument, that when someone presents themselves for voluntary inpatient treatment, they hand them the application.
That could happen. I mean, there are other federal...
Maybe they should know that that's the law.
Counsel, can I ask another question, really somewhat in tandem with this? Form MH-781, which is the form that you're relying on as the quote-unquote application, I mean, that form is actually in response to Section 7203, which is called explanation and consent. And the form is clearly a consent form. I don't see the tie between 7202, which is to whom application may be made, and this form that everyone is relying on as the quote-unquote application. This is a consent to treatment. It's not an application. I mean, to me, an application is I go to the emergency room, I present at the emergency room desk, and I say, I want to be voluntarily committed. Don't they hand people a form to fill out, like, are you insured? What is your name? I mean, to me, that would be an application for treatment. Otherwise, when do they get that information? I mean,
right.
This consent form, to me, implies that someone has been accepted for treatment.
Right. So just to sort of bring it back to the context, the sequence is, and this again is a combination of the requirements of the statute and the regs. And the regs say that this is a mandatory form. The MH-781 is mandatory. So the first is, under the statute, application for voluntary examination shall be made to an approved facility. All applications must be made pursuant to 4904, so that has to be in writing. The General Assembly directed DHS to create the regs. DHS did so. It created this form 781, and that's 55 PA Code 5172A. The use of this form is mandatory. And then it says, after the application is made, the director of the facility conducts a preliminary evaluation. And we've heard from, and I assume we'll hear from my colleague, that they keep using the word examination, but it's really a preliminary evaluation to determine the necessity and appropriateness. Because somebody could come to a facility, perhaps looking for housing or some other thing, who actually does not need mental health services. So there has to be that preliminary evaluation.
Could you just look at Form MH-781?
Yep.
I mean, it says, I consent to the treatment which has been explained to me, including the types of medication, examination procedures, and the type of restrictions that are applicable. That, to me, is an indication that whoever is filling out this form and interacting with whoever it is, they have been accepted for treatment. It has already been explained to them. To me, an application is something that would have to precede this particular step. This, to me, is just not an application, which is the context in which it's being inserted into this case. And there is no other application, is there?
As far as I'm aware, this is the only version, and this is what the regs require. But it does say before a person is accepted, they must consent, and this is the form. That consent must be in writing. They have to be given a Bill of Rights.
It also says that the treatment has already been explained to them, the treatment that they will be getting. So to me, that means they've been accepted for treatment by this point in time.
Well,
I'm not disagreeing with you. I understand your argument about the parallels and the necessity for, definitive points in time. But this 781 to me is not an application. I mean, if you're suggesting that there needs to be some written application, it has to be something other than this, in my mind.
Okay. Yeah, I mean, I think again, this is the only form that I'm aware of that is completed. I think that the overarching issue here is that if we don't have something in writing, whether it's this form or some version of that, then we are in this amorphous area that this court said was an unworkable situation in light, where we don't know if if you see somebody in the parking lot and you're coming out of the facility and they say, hey, I need mental health services, you know, where along the continuum, if you don't have something in writing in black and white, it's very difficult to know. Sorry.
Who's responsible for providing that form? Is it the hospital?
Yeah, I believe it's the hospital or the
So
facility.
share with me, with regard to the facts of this case, the individual, if I'm not mistaken, called the ambulance, and the ambulance took him to the facility. At the facility, I believe he said he was suicidal, and he was going to snap and homicidal. He was discharged, and he was told to stop alcohol, stop drugs, take daily vitamins, and contact them again, psychiatric supervision, if he is suicidal or homicidal or felt worse. 3 days later, he comes with his father, and his father says he's a danger to himself and to others. And he responds, I'm suicidal. He's been examined twice now. And at that point, he was discharged with no recommendation.
He was evaluated.
Yeah, I was going to say the word discharge is also a sort of loaded term.
He was sent home with no plan.
Okay, well, there are some factual disputes here, and there is a difference between Geisinger and Mr. Aplt will address
Right,
those issues.
This is Geisinger, I believe, correct?
It's part.
He was at Geisinger's.
He was at Geisinger, but then
Before he went to Ally.
Right, then he went to Ally, and there's a factual dispute about what he said because he was there with his father, and his father said, and the factual dispute is that they said he was on his way to Colorado. So the idea that he was asking for inpatient care, that is a factual dispute with respect to Ally. There was treatment. I mean, I don't believe there's a dispute about the fact that he was given bipolar medicine. He asked for that medicine. So again, the issue here, and
I apologize. I don't mean to cut you off. I'm still trying to find out. So is it not incumbent upon the doctor or the evaluator or the person who looked at him to hand him the necessary form for him to fill out?
Again, that is part of the sequence if it's determined that it's necessary and appropriate for him after an evaluation. And again, given the factual dispute here, there was a determination that he did not need that at Ally.
This is where I'm confused. Even under the involuntary 302, if you're a danger to yourself or to others, they're the classic line that indicates that someone should receive an evaluation. At what point, I'm trying to understand your logic as that you have an individual who twice went to mental health providers saying, I'm a danger to myself and to others, and then a second time comes back and says, I'm a danger to myself and to others, as does a third party or his dad. At what point is it incumbent upon the hospital to provide him this form that you say is necessary to do the appropriate evaluation for appropriate treatment?
Okay, and again, because this is at the summary judgment stage, we will accept, obviously, the facts in the light most favorable to the plaintiff. But the issue is that's not, I mean, according to our people in the depositions, that's not what he asked for. But even assuming that he said those things, I mean, everybody who comes in and says, I need mental health, I'm a danger, doesn't necessarily qualify for those treatment. And keep in mind, Ally is not a hospital. It doesn't provide.
Ally might have a separate defense, meaning its services do not fall within the scope of the MHPA. You just happen to be here.
Right, I got you. Yes.
The legal issue that's before us is purely this argument and this position that liability cannot attach unless the person seeking voluntary inpatient services submits a written application. That's purely what is here. So, I mean, I think the Ally might have other defenses.
Right.
But I'm kind of trying to figure out this, the statute imposes liability for willful misconduct or gross negligence. I agree with you, there's an immunity component there, right?
That was the major thrust. Yes, yes.
For anyone who denies an application for voluntary treatment, just so we're clear, your position is if someone presents to an emergency room and fills out the forms that we all fill out when we go to an emergency room and says, this is my problem today, I want to be looked at, and maybe even writes in there, voluntary inpatient treatment, they get taken back, they sit in
I'm not suggesting that what you described as an could not be considered an application, that there was something in writing and there was a formal request. I mean, in your scenario, that perhaps could qualify. Well, this form is required. That's not my argument. It's mandatory. That's under the regs.
The application, yeah, and that's not the application.
Well, I think.
Getting back to Justice Robson's example, which is what I suggested earlier, you walk into an emergency room, you walk up to a desk, and somebody hands you a form. I mean, otherwise you don't know where you are in line. And the form asks for information. Why are you here? What is your name? What's your insurance information? Things of that nature. Is that an application?
I think, and again, I don't think we have to address all the possible scenarios because in this case, there's nothing in writing. This is a black and white case. There is no application. There is no Form 781. Nothing was completed. The statute says upon written application, upon written application.
It doesn't say for voluntary inpatient, it doesn't say upon written application.
No, the statute does say that it has to be.
No, this is what the Superior Court said in its opinion, that involuntary inpatient specifically says written application.
No, I'm sorry. I was talking about the fact that there has to be an application, and yes, we don't get there. We get there. The fact that it omits the word written in our section doesn't matter because it requires that the application be made subject to the penalties under 4904, and you can't do that unless it's something in writing. 4904 only applies to things in writing. So the fact that there's not parity between the language of the two statutes for involuntary and voluntary doesn't matter if it has to be subject to 4904. But there has to be something in writing.
My concern goes back to what Justice McCaffrey asked earlier, and it's almost an impossibility situation. If someone is at the height of a mental health crisis and truly in need of commitment and wants to have voluntary commitment, it just seems so preposterous to me that they would be expected in connection with that to fill out an application.
And I
know that wasn't really a question.
I certainly take that point, but again, you know, this is a statute, and we're here applying the plain language of the statute. And if we don't have a bright line rule, then we are falling right into the trap that this court recognized. Countless resources would be expended in litigating whether various preliminary or partly formed thoughts, states of mind, back and forth, and mullings over were encompassed within the MHPA. And healthcare providers would labor in uncertainty as to whether their actions expose them.
You're reading from Light?
Yes.
Yeah, but that's with respect to an involuntary commitment, which to me is just, you know, a different scenario
We
here.
seem to be acting under the presupposition that the person's incapable of kind of a willful statement. If the entire rationale or justification behind your argument is that 4904 applies, has to apply, that's unsworn falsification. The underlying rationale behind unsworn falsification is we want to make sure that this person is, A, telling us the truth and making a voluntarily and willful statement, right? If I analogize this particular argument to, say, the criminal context, if you have someone who's not mentally competent, if we had a confession to a crime, we would throw that confession out in a heartbeat because we question the veracity of the actual confession itself because we're questioning whether or not the person made a willful and voluntary statement. Wouldn't the same apply under these circumstances and facts? There seems to be a disconnect here.
But that's only one of the reasons why we believe it has to be in writing, and because of 4904. But then also, again, under the regs, this form has to be completed after that application is made. Director of facility has to conduct a preliminary evaluation and then has to put information on this form because the second page of the form talks about treatment and the plan. It's the treatment plan. That has to be written. And then
we didn't get that far
Right.
because his request for voluntary commitment was denied. So there was no treatment plan. There was nothing to fill the form out with.
Agreed. There is nothing
So he
in
was
writing.
denied voluntary inpatient treatment.
Well, he did not reach the point of being evaluated and examined for that. He did not.
You just said you can't fill out the form. How can you fill out a form if the provider has determined you don't need treatment?
You can't. Right. I mean, if the provider is saying you don't need it, you're not going to get the consent for voluntary inpatient treatment. Yes, I agree with that.
So let me follow up one more question then. The statute provides for liability under the heightened standard for denial of treatment. Under this form and your explanation, there can never be a denial of treatment.
No, there could be a.
How can that be? If you get to filling out this form, the consent to voluntary inpatient treatment,
right,
you're being treated. You're agreeing. You've been told what medication you'll be taking, the examination procedures, other types of, that you can only leave after X number of days. That you are being treated at this point in time.
Or you're being evaluated.
Right.
That's what it's
right. Right. I mean, I think examined or treated are different.
See, but there's no liability under the Act for a misstep in evaluation for voluntary treatment. And that was my original question.
And that's a decision that the General Assembly made, again, because keep in mind, and I know one of our amici made the point that the point of the statute was to provide immunity, to increase people, because we have a mental health crisis in this country and we want more people to provide these services. So we're trying to protect people who provide those services, not to create liability. And that's why I think this is sort of ill-fitting, because it was really intended to provide immunity, not a cause of action. And so now we're trying to find out, well, how can we have a cause of action to third parties not treated by this? And I just want to...
The third-party argument is a different argument. The third-party argument is, do they have standing?
Exactly.
That's a different question than we have in front of us.
Right.
The only question we have in front of us is your whole written, non-written timing sequence argument. And so...
But there's no other option. If we don't have something in writing or some bright line of demarcation, then you will be hearing lots of cases where it's because somebody had a thought or mentioned something. I mean, in the Light case, it wasn't the patient, it was...
You would still have to prove that you made a request, an application for voluntary treatment that was denied. You could also, and that there was gross negligence or recklessness in that determination by the medical provider. Why is that not what the General Assembly intended?
Because I think, well, again, because I think it's too, well, first of all, because I don't think the General Assembly intended this statute to create a cause of action. I really don't. I think it was intended only to provide immunity. I mean, if the purposes are to increase availability of services and to put people in least restrictive environments, creating causes of action are going to do the opposite. You're going to put people into...
It created, okay, so I'll go with your language. It created immunity for anything less than gross negligence or recklessness.
Agreed.
Okay, so it recognizes an action for gross
right. But then you're going to have a situation, and you'll have this all the time, then people will say, I asked for this verbally, I have no proof of it, it's my word against the facilities, and every one of those cases will survive summary judgment because you'll have to take the language and, I mean, the allegations in the light most favorable.
The facility to protect themselves hands them a form.
But that's the whole point. The facility doesn't have to hand them a form. They don't have to have this completed if they don't believe that they actually need these services.
They deny them treatment.
Yeah, and I just want to point out one other thing because I know I don't get rebuttal, but this is not, and I think it's been conceded that this is not a failure to warn case. This is, there was some allusion to it in maybe in the reply brief, but this is not an Emmerich case. This is not a Moss case. This is not a situation where there were any threats made to any identifiable targets. This is purely either under the Mental Health Procedures Act, a cause of action, or it's outpatient care, which is really all that our facility provides.
Under your argument, and I think you've argued it very cogently, and I understand what you're saying, but, and this is quite cynical, I will admit, but isn't your position put the citizens of this Commonwealth in risk of having all risk managers in all hospitals saying, hey, if anybody comes in here for mental health treatment, don't give them the form. If they don't fill out that darn form, we're scot-free, no matter what happens.
So we talked exactly about that scenario, and I predicted that would be a question. And, you know, yeah. Well, these facilities are in the business of helping people. I mean, hospitals, their whole raison d'etre is to help people. So the notion that they're going to turn people away because they don't want to provide the services that they're, mandated to provide is, somewhat illogical. It's also, I mean, there are other federal statutes that would not apply to Ally, but EMTALA, for example. I mean, under EMTALA, under federal law, hospitals have an obligation to stabilize patients, and it's an anti-dumping statute. There are lots of other reasons why a hospital would not turn away a patient who needs mental health. And so, I don't want to say it's cynical, but I think, that's not something that I think these hospitals or facilities are in the business of doing. I'm going to allow my...
Can I ask you one more
Certainly.
question?
You sure you don't want to ask him?
I am pretty sure I'm going to ask him too. But back to my very simplistic question. You walk into an emergency room, you walk up to the desk. If the person at the desk says, here, you have to fill out our forms. If you fill out that form, is that an application for treatment?
I think that would be a closer case if you have an application in writing that says,
So you don't need this form that I don't think looks like an application?
Yeah, I mean, the form is mandatory, that's under the regs, it says it must
treatment.
be.
That's a consent to treatment. That's
Understood,
different than a form.
understood. But again, I think that's an issue for another day, because in this case, there's not anything in writing. He didn't fill out something that said, I need this treatment or I want this treatment, either, as far as I know, at Geisinger, but certainly not at Ally. All right, thank you, Your Honors.
Good afternoon, Chief Justice Todd, esteemed justices of the Supreme Court. May it please the Court, my name is Charles Eppolito, and I have the privilege of representing the appellant in this case, Geisinger Medical Center, Dr. Fitzpatrick, and Physician Assistant Davies.
Eppolito, I think it's interesting that Ms. McBride went first because her client's got a completely different argument. Your client's the front line that there's no question that your client had the ability to provide voluntary inpatient services to this person.
And I am more than happy to answer these questions that were posed, and I can start with that if you'd like. So, and I think that's, let me lay some foundation, and then I will walk through the Mental Health Procedures Act, the relevant statutes, some of the implementing provisions, not only saying that an application is required, that it needs to be in writing, but also the why and why it is in fact an application and a required one. First, this patient was treated at Geisinger Medical Center's emergency department. There is no dispute that that is outpatient treatment, and it is voluntary outpatient treatment. Under the specific scope of the Mental Health Procedures Act 103, that is very clear. In fact, this court in Light recognized that as plain and unambiguous, and it confirmed that the voluntary treatment of outpatients falls outside the scope of the MHPA. So the plaintiffs or the appellees in this case needs to do something to get this under the Mental Health Procedures Act. They're contending, now that there's litigation, that there was a request by the patient, who is not a party to the case, to be admitted. And I understand for the purposes of this argument, we need to accept as true the facts most favorable to the appellees. I understand that. That has created some of the tension, I think, with some of the arguments. Why didn't they do this? Why didn't they do that? Well, that's because, for another day at trial, there's a mountain of evidence, records created at the time and the testimony of the providers that will answer all those questions. But for purposes of today, I understand we're going to accept as true everything that they say. And I know, Justice Todd, you mentioned the ambulance. So what was said by the patient at his deposition was the reason he called the ambulance was because his car was broken, it was January, it was cold, and there was snow. So to the extent that that ambulance is going to be used by the appellees to suggest that there was some urgency there, I think that's misleading and it's not borne out by the record. But turning to the issue that I know that the justices are very interested in getting answers to. The Mental Health Procedures Act, Section 202, to whom an application may be made, that sets forth the process. Application for voluntary examination and treatment shall be made to an approved facility. Now, it's true, as has been pointed out, that that specific section doesn't say written application, but it does say application. It doesn't say request, it doesn't say informal, it doesn't say verbal, it says application. And if you also look to other sections of the Mental Health Procedures Act, such as 7114, the immunity provision, about which we've heard a lot, if you go to the last clause or two, it says, person who denies an application for voluntary treatment or for involuntary emergency examination and treatment. It uses the word application. It still requires it to be written, even though it didn't say it there. If you also look at 7302, which is the involuntary statute, subsection A just says application for examination. It doesn't say written. Later it says it's written. So then I want to continue through these statutes. So you have the one that says that an application for voluntary examination and treatment shall be made. It's required. The very next section of the MHPA is explanation and consent. Before a person is accepted for voluntary inpatient treatment, examination shall be made to him of such treatment, including the types of treatment which may be involved, any restraints or restrictions, together with a statement of his rights under this act. Consent shall be given in writing upon a form adopted by the department. So this is the Mental Health Procedures Act, Section 203, and it specifically, expressly says that before the patient is considered to be in voluntary inpatient treatment, the application has to be made and there has to be consent.
Okay, can I stop you right there?
Sure.
The section says before a person is accepted for voluntary inpatient treatment. It doesn't say application.
It's the section that follows.
I understand that, though. By the time you get to 7203, this person has been evaluated. This person has been told what kind of treatment he or she will be getting. I mean, I know that because I read the form. So this isn't an application for treatment. This is acceptance into treatment. You've had to apply before this stage. Am I correct?
Not exactly, with all due respect, Justice Donahue. There's a preliminary evaluation and discussion that occurs, but that doesn't put you under the Mental Health Procedures Act.
Well, so you don't need an application. You need something else?
You do need an application. And so the Mental Health Procedures Act then authorizes the Department of Human Services to adopt rules, regulations, and forms which may be required to effectuate the provisions of the Act. Let's look at that. Section 5100.72, applications, subparagraph A. Written application for voluntary inpatient treatment shall be made upon Form MH781 issued by the Department. And to your point, Justice Donahue, referring to the form itself, you mentioned at the top, it says before signing this form, your treatment should be explained to you and you must be given a copy of the patient's Bill of Rights. Report of your initial evaluation and the proposed treatment plan must be completed and signed by you and the physician. Then the patient has to sign this, and they have to agree to several things. I consent to the treatment which has been explained to me, including the types of medications, examination procedures, and types of restrictions which are applicable. I understand that in order to leave before I'm discharged, I must give up to 72 hours notice in writing to those in charge of my treatment, and I confirm that my rights and responsibilities while a patient in this hospital has been explained to me. It's a process.
Consent?
Excuse me?
Isn't that informed consent
Well,
versus an application? I understand what you're saying, but you're interjecting into the statutory interpretation, the department's interpretation of what an application is. Do you understand what I'm saying? I mean, there are two different sections, actually three different sections. Who may apply for treatment, to whom application can be made, and then the next one is the explanation and consent. This department has not designed an application that would fit the bill for either 7201 or 7202. They've created a form that complies with 7203, and they've called it an application.
So not only does the Mental Health Procedures Act itself require an application in those various sections I referred to, but this form, the one that has to be completed, it makes sure that the patient understands what they're getting themselves into. Most patients in this situation have signed this form, have never been through this before. And the ones that have, it could have been a different facility, a different time, a different situation. So it's a process. They need to make sure that if someone, and it's disputed whether that occurred here, but for sake of today's argument, if someone comes in and says somehow, well, according to the language of the Superior Court, all they have to do is come in and submit themselves and somehow make a request. But if they make a request in some way to be admitted, they need to make, the Mental Health Procedures Act wants to make sure, the General Assembly wants to make sure they understand what they're getting into, the types of medication, the examination procedures, the types of restrictions and restraints that they may be experiencing. The fact,
you're kind of repeating yourself on this, but I want to make sure I understand. You're saying this form that you're holding up is the form that is required under 7203.
Correct.
Okay. And 7203 says before a person is accepted for voluntary inpatient treatment, right? Where does it say before a person is denied inpatient treatment they have to fill out that form?
So that, I'm not sure where that is, but what the regulations also say is that when an application is made, when the application is made to an approved facility, the director of the facility shall be responsible for ensuring that a preliminary evaluation of the applicant is conducted in order to establish the necessity and appropriateness of outpatient services or partial hospitalization or inpatient hospitalization service for the individual patient. So it's at this point, it's not before this point, where the patient would be considered under the Mental Health Procedures Act.
You agree that the statute requires the form before acceptance?
The statute requires the form before considered under the Mental Health Procedures Act to be accepted.
Before acceptance.
Because the patient would need to consent to it as well.
Before acceptance into voluntary inpatient,
yes.
The form is required. The heightened burden of proof above the immunity level talks about the denial of inpatient treatment, correct?
Well, it talks about examination and treatment.
The decisions listed, one of the decisions is the denial of inpatient treatment.
Under 7114.
Right. I mean, that's why we're here, because this is an alleged denial of voluntary inpatient treatment, right?
That's right.
Okay. So I guess my question is, if you read those two statute sections together, then one where there is a denial, there is no reason to put a form in before acceptance, because there's been no acceptance, nor even proffered an acceptance. You were actually denied. You didn't even get to the opportunity to submit the form.
So there's one part that refers exclusively to denial, and that's one of the later clauses. It says, in the absence of willful misconduct or gross negligence, a county administrator, director of a facility, physician, or peace officer, or any other authorized person who participates in a decision that a person be examined or treated under this act. Then the next section is, or that a person be discharged, and then there's multiple variations of what could happen.
They're all different orders.
Right. Or a county administrator or other authorized person who denies an application. That clause does not apply here. This is not a county administrator. And the Superior Court did find that. So that part.
Or other authorized person, that clause doesn't even apply to
it. Does not. This is not a county administrator issue.
So there's no potential immunity or liability at a heightened standard for denial of inpatient treatment under the scenario we have here.
So if it's under the act, it would still fall within one of the initial clauses that I read. Actually, the first clause about examination and treatment under the Act. But again, the Act was, you're focusing on liability, as my colleague said. It's our belief, and it's supported by the intent of the legislature, and you've heard it in the amici brief, that this was created to provide immunity to healthcare providers and to provide certainty to protect the interests of both the patients and the healthcare providers. When the General Assembly was creating this, they didn't create it with the intent of establishing liability. So we have this tension with, well, where is the liability? But that wasn't the intent here. And this court has already found that the language is clear and unambiguous. It's a matter of statutory construction. This is what it says. Now, if you're talking about where is the liability, and this is beyond the scope of this case, but I'm being asked the question, there's common law. There's other potential.
You're exposing yourself to just regular negligence, regular professional negligence.
Yeah.
Right. So yes.
So they may. That's why I'm not sure I'm understanding why you're arguing that, because basically what you're saying to them is you're not under this statute, but you can sue us for professional negligence. But I guess your argument's going to be they don't have standing because they're a third party and
correct. They're a third party. So there's common law that would apply to a patient, but not a third party. Now there is common law that applies to a third party under the Emmerich case, and the appellees conceded that that's not an issue here, nor would it be. We'd be arguing that if they even suggested it. But the statute's expired. That's not a claim here. So there's other means, if you want to talk about where's the liability, there's other means to do it. And I just wanted to echo one thing that my esteemed colleague here said, but, you know, healthcare providers are in the business to help people, and they have the Hippocratic Oath to do no harm. And I'm not aware anecdotally of any situation where what is alleged has occurred. But there is recourse to patients. This is a case where even if you accept as true the unlikely scenario that's raised by the appellees, this case does not fall under the Mental Health Procedures Act.
Tell me again why that is, counsel, because I'm looking at 114 again. And as I'm reading it, this does in fact apply to denial of treatment of a authorized facility. It refers to authorized person who denies an application, or other authorized person who denies an application for voluntary treatment. That would apply to Geisinger, correct?
I'm sorry, where are you in 70?
I'm looking at section 114.
Yes, I'm there.
And as I understood you earlier to say that because this isn't a county administrator, the denial of treatment proviso doesn't apply. As I'm reading it, it does. Or a county administrator or other authorized person who denies an application for voluntary treatment or for involuntary emergency examination and treatment. Does that not encompass Geisinger?
It refers to a county administrator, which is not Geisinger.
Or other authorized person.
Right.
Or other authorized person. That would be Geisinger.
So,
correct? Because if it doesn't, honestly, I don't know why we're here.
Yeah.
That would really truncate this case dramatically if what we're talking about doesn't capture Geisinger. But I think it clearly does.
Well, even if you accept that it would, there's still no, they're not on the deck. There's no application. There's no application that's required by the Act.
Can you give us an example of when liability would attach, assuming that there's willful misconduct or gross negligence for a voluntary inpatient treatment?
So the first thing that would have to happen, they would have to complete the form. Okay? They would then be admitted.
So I just have a problem with this, no matter what the treatment is, whether it's appropriate or inappropriate, whether it's gross or willful misconduct, that your whole specter of decision is based upon whether a form is filled out, and it's a form that the hospital has control over. Doesn't that seem unfair to you?
Well, not at all. Part of the reason for the form is that we want to make sure that the consent is informed by the patient, that they understand what they're getting into. Because remember, that
if you're not given the form to fill out, then there never can be any responsibility.
Well, that's not true because there would be responsibility under the common law and certain other statutes. But appellees have brought us here today because they say this fell under the Mental Health Procedures Act. We're talking about, you know, the issues with which we're presented today. And there are other avenues for other patients in other cases. But as we sit here today, does the Mental Health Procedures Act apply? And it doesn't. Talking about a voluntary outpatient setting, an emergency department.
Is it possible, sorry to interrupt you, but is it possible that in the language of the statute, when the statute says application, it means an oral application? For example, a patient comes and said, hi, I'm here to apply for voluntary inpatient treatment. And because it seems like throughout the course of the statute, it does specify in various places where, in fact, it wants a written statement or a written application.
I think we need to assume that the General Assembly said what they meant, and it says application. It didn't say verbal request. It didn't even use the word request. It said application. And there are areas where they refer to involuntary treatment where they don't use the word written. And I don't know that anybody's...
Let's follow that one. Let's tease that out a little bit. So we know under 714 or 114, it says a person who's denied an application for voluntary treatment is civilly liable. We have that. Application is not defined in the Mental Health Procedure Act. Like the case indicates that must be a written form or involuntary. Therefore, why can't the word application in its statutory context include an oral request, since the word written is specifically written in the involuntary written application, yet it's absent, conspicuously absent from the voluntary, considering the purpose of the Mental Health Procedures Act is to, quote unquote, to make voluntary treatment available where the need is great and in its absence could result in serious harm to the mentally ill or to others. So share with me, how does that justify your argument that the application must be written when there's no definitive requirement of written application for voluntary treatment?
So the Supreme Court, this court in Light, recognized the importance of a bright line rule. Okay, it's to protect the patients, their due process rights. We talked about the notice, the consent, and it protects the physicians too, so they know when liability may attach. And the statement of policy of the Mental Health Procedures Act, Section 7102, it talks about the policy of the Commonwealth of Pennsylvania is to seek to assure the availability of adequate treatment to persons who are mentally ill. It then says treatment on a voluntary basis shall be preferred to involuntary treatment. It says, and in every case, the least restrictions consistent with adequate treatment shall be employed. There's a process between the physician and the patient, and there has to be a medical determination at some point. And it's been recognized, and it's cited in the brief of the amici, it's been recognized that patients generally do better when they're allowed to manage their mental health issues in their home environment, in society, as opposed to being locked up or sent away. So there needs to be an assessment that as to what the appropriate level of care is. And it's not always going to be inpatient care.
But you didn't at all come close to answering Justice Doherty's question. I mean, nobody is disputing the general principle that the General Assembly recognized that the least restrictive is supposed to be preferred. That's particularly acute where someone is trying to get somebody involuntarily committed. Because if somebody's being involuntarily committed, the idea that you would need a written application detailing all of the reasons why this person needs to be involuntarily committed, have a medical professional sign off on it, all these things, it's particularly acute there. But where somebody presents themselves and says, I can't do this anymore. I can't be on my own. I'm thinking about killing myself. I'm thinking about killing somebody else. I want to get voluntarily committed. Who's going to fight that? Who's going to say if you say no, or who's going to say if you say yes? Is that person going to then turn around and say, you shouldn't have done that? That's why you get the consent before you accept them.
consent is a process, and there's several reasons why you get the consent. You want to make sure that they understand what they're getting into. And
Right, but I guess the point is, you didn't answer Justice Doherty's question, which is when the General Assembly says somebody presents themselves voluntarily, they didn't say written application, because they're volunteering to they're volunteering to be restricted. They're volunteering to give up living at home. They're voluntarily choosing not to get outpatient treatment. Whereas the General Assembly said, but when you want somebody admitted involuntarily, a written application is required. Why don't we give meaning to that?
the importance of the certainty in that bright line that the Mental Health Procedures Act and this court referred to in light. So at what point is a request by a patient deemed to be a request for admission? Is it going to your family care provider and say, I think I need to get looked at? Is it going to the emergency department and say, I think I need some help? Is it going to the emergency department and saying, I have anxiety, I showed up here, because I showed up here, you know, that means I want to be admitted? Is it?
I'm going to kill myself, or I'm going to kill somebody, or I'm going to snap. I can't go on. Huge difference. You would have to agree to that. Say, oh, I feel depressed today. I think I may need treatment preparing that. I'm going home and I'm going to murder my mother. There's a huge difference, Counselor.
Right. I totally agree.
We're still waiting for an answer to the original question. Are you saying that the plain reading of the statute indicates that application, which is not defined, does not require an oral application, or it cannot be an oral? It must be written, and your argument is because Light said it had to be written in an involuntary, it now is required in a voluntary despite the lack of the word written. Is that your position?
And I apologize if I didn't answer it. I thought I did. It must be written. And I refer to those various sections of the Mental Health Procedures Act. 7114 refers to application, not written, application for voluntary and involuntary. 7302, which is involuntary, subparagraph A, refers to application. So, yes, it must be written, and their use of that word in the MHPA requires a written application. And I apologize if I didn't answer your question, and it took me longer. I thought I had.
Any other questions? All right.
Thank you.
Let's hear from Mr. Schaefer.
Chief Justice Todd, Justices, I'm Michael Schaefer. I represent the estate of Jessica Frederick. We've heard a lot about doctors, but what we haven't heard a lot about today is a murdered woman and her daughter, Addison, who I represent. Today, I'd like to talk a little bit about her and her family, and Wesley Wise, who presented to Geisinger Emergency Room and to Alley Medical Center, who was asking, in fact, begging for help with his father and uncle. And he was turned away. They decided that he wasn't homicidal or suicidal, and they could not have been more wrong, because within 3 days, he was homicidal and was attempted to kill himself. He was suicidal. Since we're here, this summary judgment motion has been denied thrice, 3 times. We have been litigating this case for a decade. This family has been trying to get their case in front of a jury for 10 years, over 10 years. And we are now here on the 3rd summary judgment. So, since we're here dealing with a motion for summary judgment, all the facts are deemed in favor of the plaintiff as we have established them, but frankly, some of the facts are admitted. There was an examination of Wesley Wise, no doubt about it. He was examined at Geisinger Emergency Room. He was examined at Alley Medical Center. Okay, so let's look at the statute, 714.
we go on, we're here on denial of summary judgment. Was it denied because there were questions of fact on any of the issues we're talking about?
Correct. There was a, yes, there was a denial.
That's different than the presentation that you just made.
Well, yes, because there's an admission that there is an exam, well, first of all, there was the Light decision came up, and then it was in the Superior Court, and then this court agreed to take it because there was obviously new law under the involuntary section, so this court certified it under the voluntary section. But there's no doubt that there was an examination, okay?
Counsel, before you go, I mean, I know you want to get to the statute. Before you, can you just address the unique issue with Ally in the sense that because they aren't authorized to provide voluntary inpatient treatment, they couldn't be held accountable under this section because they can't accept or deny anybody for voluntary inpatient treatment?
Okay, they are not allowed to accept someone, but they are allowed to facilitate it. In other words, they're not an inpatient facility, but they are allowed to begin the process. In other words, they can refer someone to a hospital and assist that in that endeavor. So Ally is
referral the same thing as acceptance? I mean, it looks like the statute provides a binary choice: deny or accept.
From what I understand, the statute is that they can then call an ambulance if, for example, if they had decided that if this had gone correctly, what should have happened is they should have called an ambulance and had Mr. Wise taken directly to a hospital.
That hospital would then have to be the one to make the call of whether to accept them.
Correct.
Right.
But they should have made a decision to do something. In other words, they had an obligation to facilitate a treatment plan for Mr. Wise. They could not.
Under the MHPA, where does it say obligation to facilitate a treatment plan?
Well, it says an examination or treatment. In other words, that's part of the treatment. In other words, that is under their liability.
Part of the treatment is calling an ambulance?
Correct.
As opposed to medication, programming, things like that?
Correct. In other words,
calling an ambulance is treatment?
Sure. Yes, getting him emergency care. Yes, getting him transported. In other words, if this was a surgery center.
Well, it's getting him transported, but the transport is not care; it's transportation.
No, it's
emergency. He could go to that next facility, and the facility could say, "Yeah, we're not accepting you."
Well, if this was a surgery center, and God forbid something happened bad at the surgery center, right, and there was an emergency at the surgery center, and the doctor needed that person to be transported to an emergency room, the doctor would call for an ambulance, and that ambulance would come and provide emergency care to it. That wouldn't just be, hey, we're going to get you an Uber to the emergency room. We want emergency care to give you to the hospital.
Yeah, but counsel, this is a little more complicated than that because 7202 anticipates that application shall be made to an approved facility. I mean, I'm sure you've litigated this point. Is Ali an approved facility?
They are an authorized treater, and they, as a provider, they are authorized as providing. They provided treatment to him, and they provided it. They were one of his health care. They provided mental health treatment to him. They were.
So you can present yourself there as one seeking involuntary. Voluntary commitment.
They provided him,
and they are an approved facility. I'm just reading the language directly from
correct.
that.
They provided him. They're not just a walk-in clinic. They provided him his mental health. They provided him his psychological drugs. They provided him with. They had seen him, I believe, 8 times. They provided him his Depakote.
I guess you sort of answered my question.
Yes, they are an approved facility.
Okay.
Yes. So under the statute, he has treatment. So let's talk about, and exactly what I want to talk about, what you were talking about, what is treatment. So under the facts that there doesn't have to be a form in the statute, okay? The form that we're talking about presupposes treatment. It determines that you're going to be admitted. Under this analysis, what the defendants are suggesting is, and this is actually kind of what happened here. Mr. Wise had a significant mental health issue, had been convicted of stabbing his girlfriend before, had been in a mental health institution, had committed himself before. He knew what to do. He had gone to a mental health, he had gone to Geisinger and said, help me, I need help. And it had been successful. He had snapped before, stabbed his prior girlfriend before, and he did 21 months in jail. In the emergency room record, there's a notation that he was violent and did 21 months in jail. And they decided that even though with that, and in fact his father said he was going to snap, and he said he was going to snap, and decided he was homicidal, they decided he wasn't dangerous enough. Let's put that to the test. Individual decides that he has been convicted of a shooting at Temple University. And he has mental health issues. He's already been voluntarily committed. He has shot someone else at Temple University. He has done a stint in jail for it. He has then come to an institution and said, I am a danger to myself. I am now going to shoot up Penn State University. I have guns in my car. I have explosives in my car. My father is with me. My uncle is with me. I am dangerous to myself. Our printer's not working. We can't give you the form. We're not going to give it to you. And by the way, Justice Norton decided that was his question. The trial judge said you can shield yourself from liability. He also thought of that. We decided we're not going to give you the form. Under their analysis, we're going to decide we're going to let you go.
Can you add an additional fact that you say all of those things?
Yes.
And, oh, by the way, please commit me involuntarily.
Please commit me involuntarily. Please commit me voluntarily. I want to stay. I knew it worked for me before. I want to go. I want to be here. I know it worked for me before. The physicians who have examined you to say, I don't think so. You don't have the right insurance, whatever reason, not going to keep you. Okay? And you go out and you do mayhem at State College. Is there any doubt that that the legislator would require liability of those physicians, that would be gross negligence? That's what happened here. That's what happened here. Okay? That is exactly what happened here. Because this consent form requires there to be an admission. You cannot have, and the statute specifically says that only is for whether or not there is a discharge. Okay? You can be liable for a discharge. What happened when Mr. Wise got released from the hospital? He was given discharge instructions. Okay? He was given discharge instructions.
That discharge was from outpatient treatment at an ER.
Still discharge instructions. He was still discharged from the emergency room. Okay? He was discharged from the emergency room.
You agree that the Mental Health Procedures Act does not deal with liability for outpatient treatment?
Correct. But he was still examined and treated. And
outpatient.
Outpatient. But the question is, was it done grossly negligently? Heck yeah. He murdered somebody 3 days later.
Was what done negligently?
Was that examination done negligently?
There's no, your cause of action, your claim is...
Was that done grossly negligently? Yeah.
Treatment.
Yes. That was.
Denial of treatment, not examination. The Act doesn't apply to examination for voluntary treatment. I keep getting back to this point, which bothers me apparently for no good reason, since it doesn't seem to bother anyone else. But I mean, the Act specifically does not address willful or gross negligence in the context of examination, denial of examination in a voluntary commitment situation.
Okay, well, I think it does say
you keep saying he was discharged, and that means that the examination was bad?
Correct.
That wouldn't be covered under that.
You're looking at the clause that says participates in the decision that a person be examined or treated under this Act.
Correct.
But under this Act excludes outpatient treatment.
Well, because he's his treatment, well, it's the decision to involuntarily commit him. In other words,
Well, that's later in the section.
correct.
Which doesn't apply to examination.
Right.
Well,
your problem from a statutory construction perspective, and I'm not sure why you're not willing to give this up, is a decision that a person be examined or treated under this act. It is unquestionable that the act does not apply to examination and treatment that is outpatient.
Correct.
He was being examined and treated in the emergency room as an outpatient.
Correct.
Later on, it talks about an authorized person who denies an application for voluntary
Correct. So the it's the decision to deny voluntary treatment. Correct. I'm sorry. I've got myself tied up on the prior section. Sorry. So what I'm saying is that decision to not commit him, to not admit him, not commit,
not accept his application for voluntary.
Thank you. And in the involuntary section, exactly what you said, it's very specific that it must be written, and it doesn't say that it has to be written in the voluntary commitment. It does not say that. So therefore, it is very, very clear that the application does not have to be written.
Does the record reflect whether or not he signed any application or filled out any application or form or anything? Like
Consent to treatment?
We know he didn't do that, but how
Well, he
about
didn't do that application.
He did not sign a consent for that treatment, but he signed in to the emergency room.
That's what I'm asking you. He
Yes.
signed into the emergency room. He gave them what? Name, address, insurance information?
He did not have insurance.
Like-
Name, address, and that's pretty much it. It was sparse because he came in with his in somewhat crisis, and he did have some information, but it was clear that he was applying to stay. And whether or not these floodgates will be open, the fact of the matter is that there's an allegation that he applied for voluntary admission, and that's a fact. And that fact is without a doubt that that's what happened here. And he wasn't asking, he was begging. And so was his father, and so was his uncle, to be admitted into for treatment here. And that cannot be denied. And that's why we're here, because had that happened, he wouldn't be in jail, and that woman would be alive. Jessica would be alive today. So there was ample room as to what happened here with regard to what happened here, and that's with regard to the statutory construction. There's certainly nothing in this form that says that has to be filled out, and there's certainly nothing in the statute that requires it. With regard to the involuntary, yes, there is a very, very bright line with regard to involuntary to the forms. That's your decision in Light is very, very clear as to what has to happen in Light. But here, there's no written application that has to happen under the regs or under the statute. So that's
So, counsel, it's your position then that if you present yourself at a facility and ask to be voluntarily committed, you trigger the Mental Health Procedure Act?
Yes.
Period.
Yes.
All right, any other questions? Thank you very much, Mr. Schaefer. Thank you all, tremendous arguments. Mr. Minner, would you call the next case? In this discretionary appeal, appellant was charged with 2 firearms offenses: persons not to possess a firearm and firearms not to be carried without a license. At trial, the parties and the trial court agreed to submit a special interrogatory to the jury with respect to the persons not to possess a firearm charge, which asked the jury to find whether appellant possessed and had under his control a firearm on the date in question. The jury answered no to this question and found appellant not guilty of persons not to possess a firearm. Nevertheless, the jury found appellant guilty of firearms not to be carried without a license. We must determine whether, in light of the jury's factual finding that appellant did not possess a firearm, the evidence was sufficient to sustain his conviction for firearms not to be carried without a license. Good afternoon.
Good afternoon, Chief Justice Todd, Justices of the Supreme Court. My name is Zach Goldstein. I represent the appellant, Rashid Muhammad, in this case, and we are asking the court to find that the jury's factual finding in response to the special interrogatory, which everyone agreed to, and I'm not, I'll never totally understand why everyone agreed to it. And this court, I mean, there's case after case of the court saying that special interrogatories in criminal cases are disfavored. But in this case, the trial judge agreed to it, the Commonwealth agreed to it, the defense attorney agreed to it. The jury was asked, without being instructed that this was some sort of separate charge, or that it was not going to be linked in some way to the 6106, the carrying the concealed firearm charge. So I was not trial counsel. Trial counsel did not object to the charge. And certainly I've noted in my brief, and the Commonwealth noted in theirs, that I think trial counsel should have objected, because I think there are major problems with the standard instruction to 6106, which is a whole separate issue from what we're here for today. But what the case law clearly establishes, and I cited, I think, maybe 10 cases between this court and the Superior Court, is that constructive possession is required for a conviction. Either actual possession or constructive possession is required for 6106. It is not a strict liability crime. The term possession or constructive possession doesn't appear in the text of the statute. That's clear. The special interrogatory said possession and control, I believe, which is sort of like saying possession and half of possession, because intent and power to control is the test for constructive possession. So it sort of asked. Well, I think it's duplicative, because actual possession is I'm holding it, it's in my pocket, I've really got it. Constructive possession is it's not on me, but right. And so the addition of that, I think the language of and control is superfluous and asking the same thing twice. It's asking, was there possession and was there possession? Because
are we sure that the jury saw that as superfluous?
So we can't. I mean, no, we're not sure exactly what the jury saw, other than they made a specific factual finding that there was no possession. Well, the question was possession and control. So the jury found that there was no possession and control. Constructive possession. They could have answered that question no, because there was no possession and control, but they believe there was possession or control. Well, possession requires control, so I think. Well, that's what I'm saying. Do we know that the jury made that distinction? They were instructed correctly on the definition of constructive possession. So that appears in the record. The trial judge gave I guess, when they were coming up with this interrogatory and how they were going to bifurcate the 6105 charge, the felon in possession charge, the trial judge borrowed it from the possession with the intent to deliver statute, or the drug statutes, and gave an accurate definition of both actual possession and constructive possession, and then asked the jury, do you find possession and control of the firearm, to wit, I think it was a Smith & Wesson, and the jury answered no. And so
the Superior Court and the trial court both reconciled this by citing Pennsylvania case law on inconsistent verdicts. Why wasn't this an inconsistent verdict?
So this
Why did
is
the Superior Court and the trial court get it wrong?
So the trial court cited no authority at all. The Superior Court did not cite the case law on some of the predicate offenses, which I think applies here. So I think there's 2 points. One, I'm certainly not conceding that it's the same as an inconsistent verdict. I think there are major differences between an inconsistent interrogatory and a verdict, in that when you're looking at an inconsistent verdict, you're taking another statute and looking at the elements and trying to make some sort of factual inference from what the jury did with that statute. And so it sort of leads down this road where the next thing you know, the defense is saying, well, we need to question the jurors, or we need a transcript of deliberations, and no one wants to go down that road, you know, and the jury has the right to exercise mercy, to compromise. Sometimes there's confusion, or it could be leniency. With a interrogatory, we don't have that mystery behind what the jury's doing, or
they answered a predicate fact, which is an element of the offense, and they found the element of the offense wasn't there, so they can't find him guilty of 6105.
Exactly. And so that's why I cited extensively the predicate offense case law, Magliocco, which I hope I'm pronouncing it right. I don't know if I've ever actually said it out loud to anyone else. So Magliocco was ethnic intimidation in the commission of terroristic threats. And so in that case, I think that was a bench trial. Trial judge acquits terroristic threats, convicts of ethnic intimidation. And this court held that if you're going to if the Commonwealth is going to charge terroristic threats, and there's an acquittal, then there is insufficient evidence on ethnic intimidation, the way the statute was worded at the time, because it required the commission of the predicate offense.
Share with me what weight should even be given to this question, because the question, for all practical purposes, doesn't meet any of the elements or being requested for the jury to consider. I understand Delaware County may be the only county that does this, special interrogatories, and they probably should stop it. But that being said, I don't see how what weight does that carry with the additional finding of the judge?
The additional finding of
the conviction.
Right. So I think it should be entitled to conclusive weight, because the jury was asked to make a factual finding.
But they said, I apologize. This question was asked with regard to the other offenses, had nothing to do with the VUFA case. It's just an innocuous question that I see as almost a waste of time. It has nothing to do with the offenses for which the Commonwealth was seeking a conviction of. So therefore, whether they considered that he was in possession or control, the answer came back no. What weight does that have to do with the second decision of the court, who independently took those facts and applied the elements to that element, or to the elements to that crime, and convicted him?
So
do you understand what I'm saying?
Yeah, I think so, Justice. Procedurally, the question was essentially a placeholder offense. So 6105, which is the felon in possession statute, requires telling the jury that the defendant has a criminal record. And so instead of simply doing the other charges first, and then holding a second, much shorter trial at which the record is given to the jury, and the jury, brief argument, and the jury can make a decision on 6105, felon in possession, the trial court used this unusual procedure of defining possession and constructive possession for the jury, and then asking the jury, do you find possession, yes or no? And that was going to be the verdict for 6105. Now,
you say the trial court did it. Mm-hmm. Your client did it too.
Yes.
Everybody did it.
Yes.
And so why shouldn't the intent of the mutual intent of the prosecutor, the defendant, and the court, that you all intended this interrogatory to be the de facto verdict on a particular charge, why shouldn't that prevail?
Well, it did, and the court entered the acquittal. The court treated it.
But that was it. That was your intent, was with regard to that charge. It was the de facto substitute verdict for that charge. And if you had not agreed to that, and it had been just a separate real verdict as opposed to the de facto verdict that you all agreed to, we wouldn't be here. It'd be a clear case of conflicting verdicts.
Absolutely. There's no problem with a guilty on 6106 and a not guilty on 6105. The problem is that there is a factual finding. And so
because you all created the ambiguity and wanted to live with the ambiguity, and now you want the benefit of the ambiguity.
Of course. I mean, that is the defense attorney's job.
I guess waiver doesn't apply.
That was the deal.
Right? I mean, the defense attorney, if the Commonwealth and the judge propose a verdict sheet or an instruction that's going to benefit the defense, you know,
That's the reason why, in order to be reserved to this court, we require defense counsel to make an objection to an inappropriate special interrogatory or jury charge.
So in most issues require an objection or they are waived. I think this is a sufficiency issue, which does not require an objection, and
It's
I...
not just an objection, you had affirmative assent.
Right.
This was not you staying silent on your hands and not raising an objection. This was your side saying, yeah, we're good with this. This
Right.
is fine.
Yeah, it looks to us like you're almost kind of inserting a poison pill in the actual process itself and then looking to take advantage of it.
So again, I was not trial counsel, so I don't, and if
Never a good argument in an appellate.
and if I think if trial counsel had been intentionally trying to do that, then there certainly would have been a stronger argument to this effect when the jury came back. There was some argument about it at a motion for extraordinary relief, and I think it would have shown up in the post-sentence motion. So I don't.
The jury could have come up with the contrary factual finding here. They didn't. They could have said, yes, he had possession, yes, he had control.
Right.
I mean, they just made a fact finding.
Right.
I don't know why that's wrong.
No, I think that's correct. I think the jury made a factual finding. The court.
I mean, it was a bad decision all around for the Commonwealth and for the defense because but it could have gone either way. They weren't improperly instructed on what possession or control was or anything of that nature. They just made a fact finding.
I'm going to have to jump on that one because I think, don't you believe that the special interrogatory is in fact an incorrect statement of the law? It requires constructive possession and an intent to possess. That word "and," when I read that instruction, that's a misapplication or a misinterpretation of the law. You either have the intent to possess, or I have to prove that you're in constructive possession. The way I read I don't have it with me, but I saw the special interrogatory. It specifically says, was he in possession and control?
I agree with. So it did say that. I don't think that is an inaccurate statement of the law. I think it is repeating the law. Because actual possession, then you definitely have control over the firearm. With constructive possession requires the intent and the power to control. And so I don't think it has added any requirement or subtracted any requirement that would allow the jury, that would, I mean, essentially, if I'm hearing the court correctly, it would be, is there a way that you can reconcile this inconsistent interrogatory with the verdict on the other charge? And I think the answer is no. The jury was asked, did he possess and control the firearm, which control is part of possession, whether it's actual possession or constructive possession, because there's the intent and the power to control. So yes, I think that is a strange way to word it a little bit, in that it repeats part of it. But if there's no possession or there's no control, then there cannot be constructive possession under 6106 under the case law. And so this argument that, well, maybe 6106 doesn't require constructive possession, or this is just a regular inconsistent verdict situation, I think is misplaced. And I think this court has found that with the Magliocco case, with Baker Myers, which is a similar situation dealing with corruption of minors, because the corruption of minors statute becomes a felony sex crime instead of a misdemeanor if there's a violation of Chapter 31, which is the charges like rape, IDSI. Baker Myers, I think, specifically dealt with IDSI. And in that case, it's not even as specific as an interrogatory. So here we have a factual finding that is even more specific than what you see in Magliocco or what you see in Baker Myers. In Baker Myers, it was an acquittal on the IDSI, meant that there could not be corruption of minors as the felony, and the court reduced it to the misdemeanor the misdemeanor that does not require a violation for a sex crime. And then there's been one similar case out of the Superior Court that was en banc, which was the homicide by DUI statute in Kane. Homicide by DUI requires a conviction of the DUI. And so where there's an acquittal on the DUI, even if there's a conviction by the judge or the jury on the homicide by DUI, that requires an acquittal. It renders the verdict infirm on the homicide by DUI, no matter how overwhelming the evidence was, which was specifically something that the Superior Court had written in that case. And so I think those cases, those statutes, so the homicide by DUI actually requires a conviction. That is very strong language. But Baker-Myers and Magliocco do not use the word conviction. They talk about commission or in violation of, where there is some more room there. And still, an acquittal on a different count requires an acquittal on the more serious count, which I think we have a stronger case here where the jury was specifically asked. They were instructed on possession. Did he possess a firearm? No. And if he didn't possess a firearm, then he can't be guilty of 6106.
I just want to make sure I understand your argument. Your argument is that you cannot be held liable for carrying without a license if you did not possess and control the firearm.
Possess in terms of actual or constructively, yes.
So
correct.
So that's fair. And if this were flipped and they had found possession, yes, but not guilty on the other count, your position would be consistent.
I think that there are probably situations where you may. I think possession is broader than carrying potentially. Under the case law, it requires at least constructive possession for 6106. So I cited the specific cases in my reply brief. There are numerous cases from this court. There are numerous cases from the Superior Court. There is no case since maybe in 1944, I think there was one case that had not really gone into the analysis and had said maybe it was a strict liability offense. But that's not really the issue here for today is whether or not to rewrite the elements of 6106. But the case law has held it requires constructive possession. The jury was instructed on actual and constructive possession, asked about possession, said no, he did not possess it, and that should be respected.
Okay, I think we've got it, Mr. Goldstein.
Well, just one question.
We don't. Okay.
You just said or. It should be, it's possession or constructive possession.
Well, actual or constructive.
Correct.
So actual.
Or. But the special interrogatory said, and that, I keep coming back to you, is now try to clean it up for me. You just said previously, oh no, it could be physical possession and constructive possession. But the reality is it's either you have physical possession and or an intent to constructively possess it. Or. That's what a normal jury structure would have, not the way the special interrogatory was written. Therefore, I still am coming to this point that the interrogatory in itself is a misstatement of the law. And how is that misstatement of the law applicable to the additional finding of the judge who evaluated that charge based upon the elements?
By the way, was it a judicial finding, or was it, in other words, Judge Capelli didn't find the guilty on a 6105. We went to the jury, right?
That was the jury. I think that would be a major distinction. If Judge Capelli had heard the 6105 separately, then that would be an inconsistency that would be potentially allowed, because you can have completely different verdicts on a joint bench and jury trial, where that happens most commonly in summary cases where the trial judge keeps the summaries and the jury hears the misdemeanors or felony charges. So I think that would potentially be a different situation. I think the problem is that the jury was instructed on the definition of both actual and constructive possession, meaning that the jury was told in the jury instructions, and we presume that jurors follow the instructions, the jury was told that should answer yes or no based on either one, actual or constructive possession. And that's what the interrogatory asked after they were properly instructed.
Don't placate me, Mr. Goldstein.
Yes.
Assume that how do you argue against if that were an incorrect statement of the law, that it should have said or as opposed to and as a specific special interrogatory, which is a jury instruction?
Well, so I don't think that is a incorrect statement of the law. I think if so, actual possession requires control. You know, it's in your pocket, it's in your hand, you have control. Constructive possession requires control because it's the intent and the power to control. So both actual and constructive possession require control. So I don't think, Your Honor, that it's a incorrect statement of the law.
Anything else? All right, thank you, Mr. Goldstein. We'll hear from Ms. Ware.
Thank you.
You're the closing act, Ms. Ware.
Good afternoon, Your Honors. May it please the Court, Kelly Ware representing the Commonwealth. I think defendant's real complaint here seems to be his belief that the trial court gave an improper instruction on 6106. As Justice Mundy's pointed out, the defense waived that complaint when they didn't object to the jury charge. So instead, they're trying to get around that by talking about this inconsistency. Now, when we talk about inconsistencies, Magliocco carves out a very narrow exception, an exception that applies only where the jury would have been told that the crime required the commission of a predicate offense. So that's really what we're debating here. Is count 4 equivalent to a predicate offense? And our answer is no, it's not. Count 4 is just a proxy for 6105. The jury was not told at any point that there was any connection between counts 4 and 5, and the lawyers and the judge knew that count 4 was just a dressed-up version of 6105. So we have a situation where no one in that courtroom believes these two counts work together. No one in that courtroom is considering these counts together. So why are we treating them that way now on appeal? At the end of the day, if defendant was erroneously convicted of 6106, if he was convicted under some theory of strict liability, then he has a remedy for that problem. If this is an irrational verdict, then that's sufficiency review. Then grant him sufficiency relief at that point. But the fact that he can't meet that standard isn't a reason for this court to carve out a new exception to the inconsistent verdicts doctrine, especially an exception in a case that I think we can all agree here, this case is messy. It's hard in a case like this that is so messy to really say there's going to be a long-lasting, narrow, workable, limiting principle moving forward.
Well, we can cabin our decision to these particular facts. We don't have to make it an over-encompassing rule. And we're not talking about predicate offense. We're talking about a predicate finding of fact. We can all agree that every criminal offense has predicate findings of fact, right? The jurors have to find certain elements before they can find somebody guilty, whether it's simple assault, bodily injury to another person, or intentional aggravated assault, or in this particular case, a possessory offense of a gun, right?
Yes, Your Honor.
So this was a predicate factual question that was basically dressed up to look like a 6106 charge, which is, did he possess, as Justice Doherty pointed out, possess a firearm? If they find he didn't possess a firearm, how can he be found guilty of 6105, which is also a possessory offense? This is not, in my mind anyway, and convince me otherwise, this is not an inconsistent verdict. This is a factual finding by a jury in response to an interrogatory that negated an element of the offense of 6105.
Well, I'd say first, the jury wasn't told that possession was an element of 6106. So if we're talking about...
They were told it's an element of 6105, right? That's the charge.
Possession is an element, I think, of both, but the jury was not told that possession is an element of 6106. They were never told there was a connection.
They were asked by the interrogatory to find whether or not the defendant possessed a gun,
Yes.
right? And they said no.
Yes.
So if they found he didn't possess a gun, how can they find him guilty of a possessory offense?
Because juries do any number of inconsistent things. I mean, you can take an example, I believe, in Commonwealth v. Carter from the 70s from this court. That was aggravated assault and simple assault. Well, if you assault someone, how are you guilty of aggravated assault but not guilty of simple assault? Because juries are allowed to make those decisions. Juries are not trained lawyers.
The example you just gave, a simple assault and aggravated assault, they could have found serious bodily injury and not bodily injury. So if I attempt to cause serious bodily injury and I'm charged on, and the jury's charged on simple and aggravated assault, they can say, wait a minute, he didn't attempt to cause just bodily injury, therefore he's not guilty. He attempted to cause serious bodily injury, therefore I'm finding him guilty of that. But in your example, it would be if the jury said, did you find bodily injury? And they said no. Well, then you can't find them guilty of either simple or aggravated assault.
I would say, to use a different example, see if a different one works out better.
Sorry.
Let's use an example of two different gun crimes. Here, there was one gun. Let's say he's charged of 6106 and 6108. Those can both be sent to the jury. The jury comes back, they acquit him on one and convict him on the other. It's entirely possible that the jury could be sitting there thinking, there's one gun, he should only be convicted of one gun crime. Now, to lawyers, that makes no sense. To lawyers, that's not a logical verdict, and they absolutely shouldn't rule that way. But to the jury, that's the jury doing their best to be diligent. That's the kind of diligence we should be encouraging from juries. At the end of the day, we don't know why the jury did this. They weren't told there was any connection between the two counts, so we don't know why they answered count 4 that way.
Is the record clear that they understood that these were laid out as separate counts of the indictment?
Yes, they were very clearly laid out as separate counts.
They knew that Roman numeral 4 was an indictment separate from Roman numeral 5.
Yes.
Charge. What was the charge that was given for count 5?
For count 5, the court used the standard jury instruction for 6106. They used the 3-element definition that the courts have consistently used when talking about 6106.
Do the words possess or have under his control appear in that charge for that count?
No.
Therein lies your problem. Therein lies the problem.
Right.
Because in the example that you gave earlier, and if your answer would have been different to Judge Broxton, they could have been finding guilty of one charge and not guilty of the other. And that's your typical, they were exercising lenity or something of that nature. But under this scenario, they were asked a precise factual question with no wiggle room in it. And when they answered that factual question in the negative, how do you then take away that fact-finding when you're looking at the other charge? I mean, obviously, as I think Justice McCaffrey pointed out, this is almost a sui generis situation, and maybe never to be replicated again. But in this scenario, we actually have a fact-finding by the jury, and the defense is saying, you got to live with it.
Well, I'd make 2 points. First, not to repeat myself, but I think the jury made a fact finding on a count that was intended to be 6105. They weren't told that it had anything to do with 6106. So we're imputing something to the jury when we suggest that their finding connects to the other one. But I think when you would,
I'm willing to give you that they probably didn't think they were connected at all. That goes against the notion that they were exercising any kind of mercy or lenity. I mean, they were just making a fact-finding. I mean, I think that's your toughest point to overcome here.
Well, but can you go back to, I'm not sure I understood. When the charge, in the charge I can look at in the record, but the charge for 6106, did the charge to the jury specifically say, you need to find this person guilty of this offense, you need to find that the person possesses and had control of a firearm?
No.
So that's why I don't understand. I haven't done a lot of criminal work in my lifetime. If they weren't instructed that was an element of count 5, how does their finding in count 4 of that element have any impact on count 5?
I agree, Your Honor. I think that's the problem. They don't have any impact on each other because the jury wasn't told that possession had anything to do with carrying. And that's not because the trial court made some error. The word possession isn't in the statute at all. Now,
we as lawyers and as judges understand that possession is a broad term that can encompass carrying, and that's all fine and good. But these were jury instructions that the parties agreed to giving to the jury, right? And if they wanted to instruct the jury on possession for count 5, they could have submitted that instruction, right?
yes, absolutely. And to go back to Justice Donahue's question, though, I think that point about how is this not just a factual finding, how is this a verdict, in essence, which is our position. I think if we look at this as lawyers, it's an interrogatory. If we look at this like the jury, they have no reason to believe that there's a difference. The trial court presented count 4, this interrogatory, as if it was an offense. I mean, the defense has even described it in their brief as a placeholder offense. The trial court told the jury explicitly on page 119 of it, 119 of its instructions, that defendant had been charged with possessing a firearm, and it described possessing a firearm as a crime. So from the jury's perspective, count 4 is no different than count 5. The only difference for the jury is that count 4 says yes or no, and count 5 says guilty or not guilty. Now, it's not unheard of for the interrogatories also to say guilty or not guilty, but in this case, we have a yes or no. To say that the jury would read that and say, oh, we're just being asked for a factual finding here, I think is giving the jury too much credit. I think they have every reason to believe that at a minimum, if they answer yes or no to that, this defendant is going to be exposed to some type of further punishment, because otherwise, why would they be asked the question? Well, if that's the case, then they could be exercising lenity. They could be saying, there's one gun, we only think it's fair for him to be held responsible for one gun, so we're going to pick the one that explicitly, in the instruction, contemplates the use of a car. We're going to pick the one that's closest. Now, should they have done it that way? No. It's a terrible decision. But it's the decision they made. Count 5 gets equal weight with count 4.
Aren't you asking us, in essence, to speculate what was in the jury's mind? And aren't we prohibited from doing that by our case law? I mean, that's the whole kind of object reality behind us accepting, as a court, inconsistent verdicts, because we can't put ourselves in the mind of the jury. It's like asking, do you find the defendant guilty of murder, and there's not a dead body? Well, do you find that there was a dead body here? No. Do you find the defendant guilty of murder? Yes.
I would say that the defense is the one asking for you to speculate. The defense is the one speculating that count 4 is the correct one. Our position is, please don't speculate. Go to sufficiency review.
I'm talking about speculating. This isn't, you agreed, you being the Commonwealth and the defense attorney, not Mr. Goldstein, somebody else, and the judge, agreed to an interrogatory. Interrogatory is not a charge. It's a specific finding of a fact. In this particular case, do you find the defendant possessed a firearm? No. Can we agree that possession is an element of 6105?
6106.
No, it's an element of both.
Well, that's
yeah.
Is possession an element of 6106?
Of course. It's a possessory offense, 6106.
From the case law, yes. From the face of the statute, no, which is why we have this problem, which is why this is frankly really more of a jury instruction claim, or I guess a challenge to 6106 in and of itself. I mean, that's the real problem here, and that's why it's so hard to create a rule in this case, because 6106 is a mess. This instruction is a mess. This interrogatory is a mess. This is a
mess.
Yes.
Fortunately,
looking forward to seeing Judge Capelli this summer.
But fortunately, you both gave very cogent arguments, and we appreciate it, and I'll thank you for your time.
Thank you.
Mr. Minner, would you adjourn?
Good job.
Ah.